Before we gavel in, just want to explain that this is the time of session that senators are doing multiple work groups and testifying in other committees, so apologies for the delay in commencing with the hearing. So, good afternoon, everyone. Today is Wednesday, March 9th. We have 9 bills on the docket. We'll start off with Vice Chair Wallstreicher with Senate Bill 878. We'll go to 879, 882, 842, 732, 774, 776, 783, and 704. So with that, we'll start off with Senator Wallstreicher with Senate Bill 878. Senator Wallstreicher, the floor is yours.
Thank you, Mr. Chairman. This is a straightforward bill that alters the way assets are distributed at the end of a trust to the beneficiaries. Under current law, beneficiaries must wait 120 days from the termination of the trust under any circumstances, even if there is no objection or litigation to be had. Under the bill as submitted before you, if everyone is in agreement, the assets can be distributed to the beneficiaries. Nothing changes for those beneficiaries who do not consent. In other words, they still have the right to object. It just makes things a lot easier when things are uncontested. This is already the law in our neighboring state of Delaware, which of course deals with issues like this frequently, and I hope we can have a favorable report.
All right, with that, sure. Mr. Renton.
Mr. Chairman, members of the committee, Robert Enton on behalf of the Maryland Bankers Association. I want to thank the Vice Chairman for sponsoring this legislation. The section of the law that this bill amends was a bill that passed unanimously out of your committee 2 years ago. And that bill, which there were no objections to whatsoever, this bill changes that a little bit, basically saying that the trustee, whether the trustee is resigning, maybe the trustee bank was named as a trustee, was no longer in business. Maybe the beneficiaries and all the interested parties want to terminate the trust. Bill last year basically created a process where if no one objected within 120 days, the trust could be terminated, the assets could be distributed. This bill basically is very simple. It tweaks that to just say that if no one objects, then they don't have to wait 120 days if no one objects. If everyone signs a release saying the trustee can go ahead and do it. We ran this bill by the Estates and Trust section. They had absolutely no problem with it. They thought it was a good idea. I don't believe there's any opposition to the bill. I'm happy to answer any questions. And Mr. Michael Stein, state's lawyer representing the banking industry today, if you have a question and I can't answer or the sponsor can't, I'll throw it to him. Thank you very much.
All right, questions from the committee?
Thank you.
Seeing none, thank you all very much.
Thank you.
All right, and with that, that will conclude the hearings for Senate Bill 878. We'll now move on to Senate Bill 879. Senator Wallstreicher.
Thank you, Mr. Chairman, members of the committee. Senate Bill 879 deals with an issue that happens all the time. So corporations, like all of us, make mistakes because they have human beings involved, and that means corporate directors and lawyers who represent the company, either internally or externally, sometimes make mistakes on corporate acts. When mistakes happen, there is no uniform way to unwind those mistakes. Each mistake has to be done in a common law fashion, and everyone's kind of doing things ad hoc. What Delaware has done and what the ABA has done through their model law is provide a uniform mechanism by which corporations can cure defective acts. In other words, they did something incorrectly, and they need a mechanism to undo what they've done, and this provides the guideposts for doing that. Again, this is part of the ABA model rule and Delaware law. It is essentially a safe harbor for corporations to undo acts that they did not do correctly the first time. Thank you, Mr. Chairman.
Good afternoon. Thank you, Chairman Smith. Thank you, members of the committee. I'm Bill Carlson, Chair of the Maryland State Bar Association Committee on Corporation Law, and I'm here to support Senate Bill 879, and to thank Senator Waldstreicher for sponsoring this legislation. Senate Bill 879 would add a new subtitle 7 to Title 2 of the Maryland General Corporation Act, providing a statutory safe harbor procedure for a corporation to ratify a corporate act, transaction, or issuance of stock that is void or voidable because of a failure of authorization. There might have been no action by the board of directors, or the board took action that was contrary, or they forgot a detail or a certain procedure under the charter bylaws or an agreement. Right now, or could have not gone to the stockholders, or there could be other reasons why there's a failure of authorization. Right now, as the senator alluded to, it's kind of a hodgepodge of different common law type of approaches. There might be waivers, consents, rescission offerings. Sometimes people are comfortable with how it's been ratified. Sometimes people are uncomfortable and uncertain. So we plan to follow the Delaware Act and the Model Business Corporation Act and provide something in the Maryland General Corporation Law. The statute in 2701 has a set of definitions, and 2702 through 2705 has the mechanisms of process. You go to the board. If you're required to go to the stockholders, you go to the stockholders. Who gets notice? All the mechanics of that. And there's a new charter filing called Articles of Validation. If you forgot to file it or you filed something incorrectly, your articles of merger are all goofed up. Well, you file Articles of Validation declaring that you had done a ratification. 2706 provides an option for people who are disgruntled to go to court and sue and say, well, that's nice you ratified it, but you hurt me, and let's duke it out. 2707 says that this is not the exclusive way of doing it. It's merely one way of doing it. I'm happy to answer any questions that anybody may have on the committee.
Thank you, Mr. Carlson. What's your last piece there? I was just curious. Just in general, what is the mechanism for people who have relied upon the previous corporate action? How do we protect those who did rely upon that?
Well, if somebody's been adversely affected, they could sue the corporation for damages. I mean, usually it's the other way around. Normally it's that they have a stock certificate and they're being told it's worthless and they want it to be made valid. So I would say the great majority of times it's someone who wants certainty, who wants to be helped, who wants to have something that's invalid to become valid. I think it's going to be much less often that someone was hurt by the ratification. Someone may have bought shares that are worthless, and now they want them to be valuable. Usually those are between the people who've been selling the stock, not the corporation.
And if I am somebody who's adversely impacted but don't know it, is there like a discovery rule applicable to this? So, hey, I didn't even know you guys rescinded that part of the...
You would have to receive notice.
Okay. I'd have
So
to actually...
we would give you notice, and you have to respond. If we don't tell you and we do it behind your back, then you could sue a year
I
from now.
can pursue it until... Thank you.
Right.
Appreciate it.
Yes.
Thank you very much, and good afternoon.
Afternoon.
Is this, I'm assuming this would also be applicable to non-stock corporations? I mean, at least, not the over-issue piece, but the Defective Corporate Act under C1?
Yes, it would be. Under Title V, and the portion of Title V dealing with non-stock corporations, all those
It captures
rules,
all those.
they suck in all that, so this would
This would fall under
benefit
that.
those corporations, yes.
Thank you.
Further questions from the committee? Seeing none, thank you both very much.
Thank you very much. Appreciate it.
And with that, that'll end the hearing for Senate Bill 879. We'll now move on to Senate Bill 882. Is Senator Lamb here? Senator Watson, are you ready to go? Okay, excellent. We'll start, so we'll scratch that. So belay the last, we'll go with Senator Watson, Senate Bill 732.
Thank you, Mr. Chair. House Bill 732. House Bill 732 bans the use of mass-produced documentation, also known as robo-signing, by requiring collectors to prove private student loan debts are valid when attempting to collect. This bill places the burden on creditors to certify that old debts are not barred by state statutes of limitation, preventing creditors from obtaining judgments against borrowers for time-barred debts. This protection will prevent creditors from obtaining court orders to garnish wages and seize assets to repay defaulted student loans. that creditors cannot prove borrowers owe. As an overview, Marylanders continue to feel the economic pain of COVID-19. One group of economically vulnerable constituents have been left out all the conversations regarding relief, and that's private student loan borrowers. These borrowers were excluded from all federal relief packages and collectively owe more than $100 billion nationally, often at higher interest rates with less protection than borrowers with normal federal student loans. Private student loans are often the last resort for students who've taken the maximum amount for federal loans. Because many private loans require co-signers, the financial repercussions can span generations. Lack of oversight of private loan creditors has led to disastrous consequences from these borrowers. Similarly to the subprime mortgage crisis from several years ago, economically vulnerable borrowers across higher education landscape were targeted by predatory private lenders a decade ago and continue to struggle and fall behind on these debts. For more than 2 years, law enforcement officials have brought significant federal and state litigation alleging predatory lending by the largest private education lender and alleging abusive collections, robo-signing, and illegal pursuit of invalid debts by collectors, investors, and servicers. These cases expose significant systemic flaws in the way the judicial system approaches private education loan debts, particularly in terms of wage garnishments. These student loan creditors are seeking judgments every day to collect on loans they cannot prove they own. Because they lack proper documentation, these companies are lying both to borrowers and courts, including Maryland courts, about their legal ability to sue borrowers to obtain and garnish wages. NCSLT, National Collegiate Student Loan Trust, just one of those creditors, owned more than 15,000 separate loans owned by Maryland borrowers, totaling more than $190 million. The federal government has ordered NCSLT to pay over $20 million for its deceptive acts in the past. Just a little bit more. In addition to an analysis of court findings in Maryland by the Student Borrowers Protection Center shows that this is just one creditor. NCSLT filed 1,334 cases against Maryland borrowers in the past 5 years alone. These cases disproportionately target communities of color in Maryland. More than half of the lawsuits analyzed are against borrowers in majority-minority zip codes, and almost 26 of all lawsuits analyzed were filed in Prince George's County, which, as the committee knows well, was the center of Maryland's foreclosure crisis a decade ago. In addition to people of color, senior citizens are also disproportionately impacted by this abuse because the borrowers of private loans, in many instances, require a co-signer, parent, or grandparent, frequently defaulting on private student loan debt. According to AARP, 37% of student loan borrowers are 65 and older. In conclusion, this bill prevents these abuses from happening in Maryland by requiring creditors to provide specific evidence in wage garnishment lawsuits that proves that the loan is in default and that they are the creditor owed the loan. This will ensure that private loan borrowers in Maryland do not fall victim to predatory and unsubstantiated lawsuits. This bill passed in the House last year, 130-3. I asked for a favorable report on Senate Bill 732. And I think I may have two people to testify, I think.
Excellent. Thank you very much, Senator. And yes, we have Winston Berkman-Breen and Kathleen Highland.
Thank you. And I'll just note that Ms. Highland was here but seems to have stepped away, so I messaged her. Hopefully she'll be here in a moment.
Okay, great. Thank you.
Thank you for that. So good afternoon, Chair and Committee. Thank you for letting me testify. My name is Winston Berkman-Breen, and I'm the Policy Counsel at the Student Borrower Protection Center. We're a national policy nonprofit focused on ending the student loan crisis. Prior to that, I was the student loan ombudsperson for the state of New York and a legal services practitioner doing debt collection defense cases related to student loans. So it's from these perspectives that I testify in support of SB 732. I've submitted written testimony, so I'll just highlight the major points now and then answer any questions. So critically, this bill would enact very specific protections that are narrowly tailored to known abuses of the state court system by private student lenders. Mainly that too often creditors obtain judgments for loans that they do not actually owe or for which they lack even the most basic documentation. These court abuses are paid for by the low-income borrowers whose wages are garnished and bank accounts levied and frozen. These abuses are not hypothetical. As the Senator mentioned, last year we partnered with several Maryland organizations and published a report exposing the collection practices of just one company in the Maryland court system, the National Collegiate Student Loan Trust, or NCSLT. The report is included in my written testimony. NCSLT, which owns over $190 million from Maryland residents, has sued over 1,300 of them since 2015, using the same robo-signing tactics we saw during the foreclosure crisis. These abuses disproportionately harm communities of color in Maryland. Over 60% of the lawsuits were filed in majority-minority zip codes, with 1 in 4 filed in Prince George's County, as the senator mentioned. These practices are not limited to the NCSLT. Now, all this bill would do is codify and clarify that creditors must prove they actually own the loans that they've sued to collect. This is not radical, and I think we all expect them to do this anyway. It does this by requiring them to file these documents in court before they can obtain a judgment. This bill has been successful in the House, and this year we hope it can be successful in the Senate as well. This is the time to pass this protection measure, certainly as many of the other COVID relief programs are winding up. So happy to answer any questions, and we'd ask for a favorable vote. Thank you.
All right, thank you very much. Senator Castley.
On page 8, talks about disclosing whether the debt can be discharged in bankruptcy. Can the debt be discharged in bankruptcy?
Yes, thank you for that question. So I think there's a very common misconception that student loans cannot be, or that they have a heightened burden for discharge in bankruptcy. We actually just filed another report on this, happy to follow up with your office. It's actually a very specific type of student loan, and creditors can tell the difference. So it's a not particularly helpful misconception for borrowers who could benefit from bankruptcy but believe they can't. So that's why we want them to take a stand. They know their portfolios. If they think it can't be discharged, say that. Otherwise, make sure consumers know bankruptcy might be a good option for them.
Okay, thank you.
Sure.
All right, further questions from the committee? Seeing none, thank you very much. Thank you.
Thank you.
All right, so is Ms. Highland here, or?
You know, I will double check again outside. I did send her a message, but
Okay.
hopefully I'll try to grab her.
Okay,
And I
thanks.
believe there may have also been someone from the Attorney General's office here, but I'll double check that.
Okay, yes, and then Lance, sorry, yes, Lance, that's right, sorry, yeah. Okay, I think that's it. So with that, that'll end the hearing for Senate Bill 732, if Ms. Highland's not in the room. Now we'll move on to, we'll go back to Senator Lamb. Senator Lamb is tied up in committee, so we will have, we'll just start off with Lance Kilpatrick. Is Rachel Sessa here? You want to come on up? I know you're here for information. And then Errol Edding. And Lance, if you want to start us, or actually we had, yeah, Lance, if you want to start us off. At your pleasure, whoever wants to go first.
You know, we so often don't let DPSCS go first. Maybe we should this time.
Oh, thank you, Mr. Lance, appreciate it. Ready? Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. My name is Tara Nelson. I am the Acting Director of the Department of Public Safety and Correctional Services, Human Resources Services Division. I'm here today to provide informational testimony on Senate Bill 882. Over the past 2 years, the department has hired nearly 1,000 correctional officers, and we continue to prioritize hiring across all positions. However, the department is experiencing a decline in the number of overall applicants. Despite all of our efforts, we know it can deter individuals from submitting an application, as there is a stigma associated with a lie detector test. I think it's important to note that over the past 6 years, the department has made significant improvements to the hiring process to ensure it is hiring qualified and suitable candidates. Besides the polygraph examination, the department uses multiple screening tools, including a psychological examination, a background investigation, interviews, physical examination, and a drug test to determine suitability for employment as a correctional officer. The psychological examination results are carefully evaluated by the department's licensed psychologist, who makes the final determination on suitability for hire. In accordance with COMAR, correctional officer candidates must undergo an in-depth background investigation, which includes investigators reviewing and corroborating information about employment history, financial background, illegal drug use, gang affiliation, and criminal history. Lastly, I think it's important to note that while the department has significantly reduced the time frame it takes to hire a correctional officer, we estimate the time from application to hire could be reduced by an additional 21 days if the applicant was not required to take the pre-employment polygraph. I hope this information is helpful as you consider Senate Bill 882. Thank you.
Thank you, Mr. Chairman.
Good afternoon, Chairman Smith, Vice Chair Waldsteiger, and members of the Judicial Proceedings Committee. My name is Errol Letting. I'm the Executive Director of the Department's Intelligence and Investigative Division. Since 2016, the Department has significantly bolstered its corruption reduction efforts. In May 2016, the Department established within the Intelligence Investigative Division a Special Investigative Unit. This unit is composed of experienced law enforcement officers have worked on major drug, corruption, and homicide investigations. Their investigative experience includes wiretaps, financial transaction, and money laundering. We have partnerships with detectives embedded at the FBI, DEA, U.S. Attorney's Office, and Maryland Attorney General's Office to ferret out the corrupt activities. The Department has also established an analytics unit tasked with utilizing certain systems to identify potential employee and inmate fraternization. In addition, we have ramped up our utilization of our contraband interdiction team, which is a team of correctional staff highly trained in the area of contraband concealment and recovery. The incarcerated population frequently seeks to exploit an individual's correctional officer's vulnerabilities in an effort to influence that officer to engage in actions that violate the department's policy and public safety, and sometimes to actually commit corrupt acts. We have seen correctional applications pass the pre-employment polygraph, unfortunately to be later arrested and indicted on corruption and other misconduct charges. While the polygraph examination can be a good tool to measure physiological response to certain questions, it is not completely indicative of truthfulness or proneness to be swayed by undue influences. Thank you for the opportunity to present this information and available for questions.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the Judicial Proceedings Committee. My name is Rachel Sessa, and I'm the Chief of Staff of the Department of Public Safety and Correctional Services. I, too, am here today to provide informational testimony on Senate Bill 882 and answer any questions you may have. If SB 882 were to pass, the department could utilize a pre-employment polygraph to assist in clearing candidates who may have had issues that arise during the psychological examination or the background check to further clear and verify any inconsistencies. I would also like to note that pursuant to the bill, the department will be required to promulgate regulations stipulating the circumstances under which human resources would require an applicant to undergo a pre-employment polygraph. These draft regulations would have to be reviewed and approved by our Office of Equal Employment Opportunity, as well as an Assistant Attorney General. So there would be multiple layers of review to ensure the potential use of the pre-employment polygraph would be fair and equitable. And, as I'm sure all of you know, all draft regulations must go through the AELR committee, so there'll be the opportunity for legislative review as well. Thank you again for the opportunity to testify on Senate Bill 882, and that completes my testimony.
All right, we'll go with, yeah, go ahead, Lance, and then I know we have a number of questions.
Thank you, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. For the record, my name is Lance Kilpatrick. I'm the Legislative and Political Director for AFSCME Council 3, representing approximately 30,000 state and higher education employees, including the very correctional officers that we're talking about here today. It's not a secret that DPSES has for years now had troubles maintaining the level of correctional officers needed to staff our facilities. And we believe that part of that has been an onerous hiring process that should be remedied. One of these things is the polygraph exam that my management colleagues have been discussing. even though the National Academies of Science and the American Psychological Association both have called into question the accuracy of using polygraph exams for such a screening process, it has served as an obstacle that needs to be overcome for an otherwise qualified individual to join the ranks of the Division of Corrections. Disqualification could arise simply because of nervousness, changing an answer to a question, things along those natures. These types of things, particularly because of lack of accuracy, shouldn't serve as a disqualifying factor for someone who's looking for employment within DPSCS. I would also say that AFSCME ultimately believes that the greatest incentive to hire and retain correctional officers within the system is to continue wage and benefits enhancements. And I will give credit where credit is due. Secretary Green has definitely taken positive steps towards that, so I want to acknowledge that. But we also urge the removal of ineffective yet disqualifying processes, which actually hurt the hiring of folks that is so desperately needed. So with that, AFSCME Council 3 asks for a favorable report on this legislation. Thank you.
Excellent. I know we have questions, but before we get into the question panel, I want to give Senator Lamb is here an opportunity to speak on behalf of the bill, and then we'll switch to the committee for questions.
Thank you, Mr. Chairman. Clarence Lamb, Senator in District 12, also the chair of the Joint Committee on Fair Practice and State Personnel Oversight, which this came under. The purpose of the bill, I guess going in reverse now, is to assist the Department of Public Safety and Correctional Services in filling vacancies in correctional officer positions by changing the requirement that applicants undergo polygraph test to be at the discretion of the department as opposed to a mandated procedure. This allowance for the department to develop procedures to strategically utilize the polygraph requirement will help prevent otherwise qualified candidates from either being totally deterred from applying in the first place or by dropping out of the hiring process during the extended time frame that it takes to complete a polygraph investigation. Correctional officers are tasked with the care, custody, and management of incarcerated populations in Maryland. Across the state, there are 18 correctional facilities operated by the department, in addition to various pretrial and specialized treatment centers. The department is currently struggling to fill correctional officer vacancies across the state, despite offering numerous employment incentives over the past several years. As all of us are familiar with, there's been an increasingly difficult time to be able to hire employees across the board, not just within state government, but otherwise elsewhere as well. The department has raised salaries more than 22% since 2018 and offers generous signing bonuses, including bonuses that incentivize those with previous corrections experience to apply, and bonuses to also help recruit individuals to facilities in areas that are harder to recruit. Understaffed facilities lead to mandatory overtime for existing staff that puts a strain not only on them, but also on their family. The department utilizes significant resources to cover this overtime payment structure to the tune of about 15% or $150 million of its operating budget. The pre-employment polygraph requirement was instituted in 2015, following the indictments of 24 correctional officers on charges of corruption. However, at that time, there was a heightened need for the legislature to act immediately, and this was more than a reasonable response to those occurrences. In the years since, the department has responded by operationalizing an investigatory unit composed of talented criminal investigators, whom you've heard from, and who will be here to also help answer some of these questions. It's important to also note that the background investigation applicants undergo more of an investigation than a simple background check. This includes personal and professional reference checks, fingerprinting, complete local, state, and national background checks, psychological evaluations, analysis and photos of any tattoos, amongst other provisions. While a polygraph in some instances may be an effective tool in a hiring process, there are a multitude of reasons that affirm that it is best used in a strategic manner, in a targeted fashion. As I said before, the polygraph requirement extends the hiring process unnecessarily for applicants who are otherwise qualified for these roles and makes it more difficult to fill these important positions in our state government. The polygraph requirement is not required in any other jurisdiction surrounding Maryland, including Pennsylvania, Delaware, Virginia, West Virginia, and D.C. In fact, there are 5 states that outright ban its use in state employee hiring procedures. That includes Massachusetts, Michigan, Minnesota, New Jersey, and Oregon. The reason for the polygraph is not used as a universal tool in hiring correctional officers is that it's often seen as an unreliable metric to measure deception. There are numerous factors that can contribute to an individual's autonomic arousal response on these tests, which these tests measure, which can have nothing to do with lying. The polygraph measures skin conductivity, heart rate, and blood pressure. It's hard to imagine how one's blood pressure might be affected in these tests when all you've seen these tests are only in movies or on TV. Additionally, there are ways that people can beat these tests by manipulating these reactions to certain control questions, for example. And because of this, courts accept that the polygraph evidence is largely unreliable and generally find such evidence to be inadmissible in court. Thus, while the bill will remove a requirement for a pre-employment polygraph test, it will still retain the department's authority to employ a test as they see fit. This bill provides the department with another tool to assist in the hiring process of correctional officers by providing discretion in the use of pre-employment testing. And with that, I'd like to thank my sponsor panelists who have already come up here and be happy to answer any questions as well.
Excellent. Thank you, Senator Lamb. All right, we'll now move on to questions from the committee. I'll start off with Senator Huff and then Senator Carter.
She's going to go first.
Sorry, Senator Carter. I saw you first, Senator Huff, so. go ahead.
Thank you, Mr. Chair. So, Senator Lamb and panel, I have a few questions because you addressed it, some of you in your testimony, but you probably recall that we intentionally created this law in response to the corruption that was highly publicized years ago. And it's my understanding there's been a myriad of incidents even since then. We also wanted correctional officers who are in such close proximity with temptation to use this as a tool, not to say it's the be-all, end-all, but to ensure veracity, which is important in this profession. We also wanted it to be you to be in parity with law enforcement officers, which were required to do it, I believe. So that being said, I did have one question for you, Senator Lamb, or whoever wants to answer the question. You said you've all testified that it's this unnecessary burden in the course of hiring, and you need to hire more people. How many people, what percentage of people are disqualified for having failed the tests that are given to them at hiring?
Thank you, and if I may, Senator, thank you so much for that question. I know our Acting Director of Human Resources and Services Division absolutely tracks those, and I think we have a 77% passage rate of the pre-employment polygraph. And again, so we do know that the overwhelming majority of applicants do pass a pre-employment polygraph. It does add additional time, and again, it could be utilized in instances where individuals, have a stellar background investigation, but there's inconsistencies, and so we go back and apply a pre-employment polygraph to try and rectify any of those inconsistencies. But where in instances where an individual, there are no red flags, no inconsistencies throughout their personal history statement, the thorough background investigation, and everything else checks the box for them to be able to proceed in that process. And I would also like to note that the agency does have the statutory authority to conduct a post-employment polygraph examination if there is an issue that arises in the future.
Thank you. And the final question or concern that I have, and the reason that in the past I've supported continuing the mandatory pre-hiring polygraph test is because I am concerned that when there is discretion, there will be disparity. I am not comfortable with leaving it up to the discretion of the hiring entity or the hiring authority to cherry pick who will and who will not get a pre-employment test. And so that's why I think it's just more fair to do it across the board. And I'm thinking that if 77% are passing, perhaps that other percent might actually be people that we don't want to be correctional officers. I don't know. That could be the case. So that is the concern, if you have any response to that, the use of it in a disparate way, which happens usually more often than not whenever we allow discretion. Thank you.
Thank you, and Senator, if I may respond, I heard you loud and clear. I so appreciate the question, and as previously stated, obviously we would be required, the agency would be required to promulgate regulations stipulating the circumstances under which the agency would be required to use a pre-employment polygraph. So if during the psychological evaluation, the psychologist recommends the utilization and that individual conducts a blind or they don't have the opportunity, they only receive the information at hand, they don't actually see the individual applicant, and so if they review during the psychological evaluation and feel the need that a pre-employment polygraph would be beneficial, that could be an opportunity. But again, for that to proceed in utilization of the pre-employment polygraph. But again, regulations we would be required to promulgate, which would undergo strict review by our OEO, by the AAG, and of course by the Legislative AELR Committee. But thank you, Senator, for that question.
Yeah, thank you. So how many questions is your polygraph?
Thank you, Senator, for that question. If I may, I defer to our Acting Director of Human Resources Services Division if she has that information available.
Yes. The polygraph actually is a test that is spawned from the personal history statement. I apologize, you may not be able to hear me. Thank you. And our personal history statement is a 41-page document. And so the questions pertaining to 6 target areas: theft, gang activity, domestic violence, serious crimes, those are the target areas that are surfaced in the polygraph examination.
So I'm looking at, because I'm looking at the state police, they've got a 29-page polygraph they require. So isn't it accurate that the state police and most police departments in this state require a polygraph prior to hiring?
I'm not aware of all of the law enforcement jurisdictions, but I do know that the state police does require that for their law enforcement officers.
I mean, like, for example, here's some of the questions that they ask. Have you ever accepted any bribes? Have you ever used excessive force? Have you ever, have you ever lied or covered up for police officers? There's tons of questions on here, but the reason why those questions are so good in the gang affiliation, I mean, I should say I have a personal attachment. This was actually my bill. We did it after Baltimore City, after that jail was taken over. And I can say that was one of the most horrific things I've ever seen. I could not imagine having a family member or friend or somebody who was incarcerated there and having the guards completely corrupted like they were. I mean, your lives were literally in danger because of the corrupt nature of it. And I guess the shocking part to me that this bill's in front of us is that incident wasn't isolated. I just did a quick Google search while I was sitting here. 2019, 20 indicted. This is in the Department of Public Safety in our facilities. Federal indictments, ECI, there were 80 indictments, 70-plus convicted, 15 charged at Jessup, 2017, 26 indicted, secured, working with high-level gang members, 2019, 25 correctional officers charged, 2021, Baltimore, 3 correctional officers indicted, 2021, a smuggling scheme. Here's another story, 20 indicted. I mean, we've had numerous I find it interesting, maybe you all can respond about these efforts that are being made professionalized. It seems the system is still plagued by corruption. I mean, this is just what I Googled in 2 minutes while I was sitting here, this number of indictments and corruptions in our system. I mean, ECI alone was 70-plus convicted correctional officers.
Senator, if I could just answer that, these were all cases brought by Public Safety and Correction Investigation in cooperation with the FBI, other cases DEA, and that's what I was referring to in terms of the joint investigation. So our point is we're actively looking for corruption. Unlike the previous cases, BCC, this is department initiated virtually all these cases on that. So we are addressing the corruption issues.
And it's a good point, but the point actually proves why the bill is before us, because these are all folks that have already been hired. They made it through the polygraph test.
They made that, but with all due respect, that may not be accurate because this requirement only went into law in the last couple of years, like 5-6 years. And I don't know that it's accurate to say these people were hired in the last 5 or 6 years.
I mean, I'll defer to the department, but if you look at the turnover in some of their hiring positions, a lot of them probably were hired within the last 5 or 6 years just because of the churn in these state positions. But I think it does prove the point that there are folks that can get through a polygraph test, that a polygraph test is not bulletproof. And I think to some of the panelists' point earlier, what they've instituted since 2015 is a broader look at these applicants, that they're looking at a comprehensive background check, state, national, local background checks. They're photographing tattoos. They're asking people questions. It's more comprehensive in many ways than the polygraph was. The polygraph, I think, was a good, fix at the time, but I think we've moved beyond that, and I think that's why they're before us for this.
Well,
for this
well,
bill.
then, would you be in favor of us dropping the polygraph for police?
I think that's a different circumstance. So, I think with police, they have a different skill set. I think they're, bringing different skills there, different experiences that are required. The pay is quite a bit different. And so I think there are certainly differences there when you look at police versus correctional officers that make these positions particularly difficult to fill. And we need folks to fill these positions. We need good folks to fill these positions, otherwise we will have other issues within our facilities as well. And so this is intended to try to address that in a narrow way by allowing them a little more flexibility to be able to do that beyond just the polygraph, which is now stipulated as a requirement.
Yeah. Well, and the last question is, isn't it correct that when somebody fails one of these polygraphs, that you're able to do a process and do further interviews with them and then actually hire them?
If I may, Senator.
Yes.
The polygraph does also reveal some inconsistencies in terms of admissions. And so just because they are truthful in the polygraph, they may make an admission that would warrant them not a suitable candidate. And in terms of a follow-up, the breakdown tests are already done at the time. Some agencies offer to do a subsequent interview following the polygraph, but our process right now allows us to do the further breakdown questions at the time of the administration.
Okay, so they do their polygraph. You see inconsistencies on the polygraph. You are allowed, with that 77%, they're good, they make it through. The ones that do not, you're allowed to do subsequent questions and still get them through, are you not?
The breakdown, yes.
Yeah. Thank you very much.
But I think the point is that the polygraph not only serves as a blocking function, but it also may preclude people from applying for these positions too, that they're turned off by the need to have to go through a polygraph exam.
Absolutely. And having sat here in this very room after that Baltimore City Jail was taken over, one of the reasons the polygraph is you're looking for gang affiliations because gangs had taken over our facility. And if you look at the headlines, it's clearly still an issue. So that's the purpose for the polygraph, is you're looking for the gang affiliations.
But it's been an issue even with the polygraph in place.
Well, I don't know
So
how this would make it better.
I think the intent here is to have a broader look, beyond just one test, to have a comprehensive look at that person's background, their history, affiliations, tattoos, et cetera, to be able to decide with a broader look whether or not that person's appropriate to be hired. And given the current hiring state that we're in, oftentimes not only having a polygraph test will turn people off, oftentimes that will slow down the process that they'll get hired somewhere else.
Of the 77% that passed, those that failed, how many did you then do the subsequent question and get them through?
I don't know if I have that particular, I can get that information to you, but I do know that the breakdown tests are administered at the time that it's offered. And if they don't clear multiple sections, that's 3 or more, then we wouldn't do a breakdown. So if they show signs of deceptive in 3 areas, we won't do the breakdown. It's likely that the candidate at that point has some significant discrepancies and possible deception.
Thank you.
And if I may address the matter regarding the gang affiliation, just to be clear, our background investigators currently, most of them have over 25 years of law enforcement experience, and we've been able to disqualify for gang affiliation, and it doesn't have any involvement with the polygraph. So we are very robust in looking at those connections, either through affiliations, known associates, our gang databases. We also check inmate contacts through visitor logs and through telephone contacts. And I think we've been able to definitively know when someone is affiliated in the hire process with someone involved in gang activity. So to that extent, our investigators do an excellent job of researching and finding that information out.
For the people that are deceptive on 3 or more areas, why would you not want to have that? 3 or more areas would be what? What are your 3 areas?
Those would be 3 of the target areas. So if it's theft, illegal drugs, domestic violence, serious crimes, sexual offenses. And out of those areas, this is with APA standards, American Polygraph Association standards that we follow. And those are the same standards that are set in those guidelines, as well as the state police.
All right, thank you.
Yeah, just really briefly, is there if I go and take this polygraph and I fail every question, I mean, you think it comes back to, you think I've bold-faced lied on all, was it 42 questions? 42 questions? Is that what it was, 42? Whatever. Yeah.
Yeah.
Yeah, and it comes back that you are just the most, you lied on everything. Am I subject to some kind of criminal charges or anything? It's just, no, you failed, go away? What happens?
Thank you for that question.
Yeah.
Meaning if you fail the polygraph, then the investigator, that becomes part of the investigative packet. And so it's not a complete disqualification, but it's part of the assessment tools that we use. And so quite often, the information in the polygraph is corroborating information that an investigator has already discovered in their thorough background. So once again, if it's deemed that the candidate is not suitable based on that information, it's tabulated and cross-referenced with other information sources.
Right. No, I guess in certain time, you fill out certain federal or state forms. At the bottom, it says, is under the penalty of perjury, right? So if I lie on those forms and you discover I've lied, I can be prosecuted for making a false statement on those forms. If I now go to you for a job and I take your polygraph and the polygraph operator says, we think you lied on every question here, you don't get the job, am I now subject to some kind of a criminal penalty for lying on a polygraph?
We have not taken any action for administrative processes.
Okay, so
That's not criminal.
So it shouldn't, the fact that there's a polygraph being given shouldn't discourage me from, if I want to be a correctional guard, the fact that I might fail this thing miserably shouldn't discourage me from at least trying. That
It
alone.
shouldn't discourage you, and it shouldn't discourage you from reapplying. In fact, we have had candidates who have not been successful in our polygraph in prior submissions, but have returned later on and have been successfully hired. So it's not a permanent disqualifier either.
So I'm just trying to understand in my own mind how this polygraph piece of this is responsible for keeping out people that we want to have as DOC guards. That's my challenge right here, because all I've heard so far is we get 23% fail, and of those, we go back, we give them an opportunity. But if at some point we say, we don't really want you. Now, if we don't give the polygraph, I never would have known that. But the polygraph says, you've failed too much, so we don't want you. So now we're going to say, well, let's not do that. Let's not even ask those questions, so we won't know that we don't want them. And it just reminds me of the it seems like our approach here is the Fleetwood Mac song, just tell me lies, tell me sweet little lies, that as long as I don't know you're lying to me, everything's okay. But don't let me know you're lying to me, because then I wouldn't be able to bring you on. How is this not a Fleetwood Mac syndrome here?
If I may, Senator, thank you for that question. So in terms of, and just to kind of be clear about, correctional officers' roles, responsibilities, and duties. So again, this bill is not saying, the department will still continue to use pre-employment polygraphs. Absolutely. Mm-hmm. This just gives the agency the discretion to determine at what trigger point is the pre-employment polygraph to be utilized. Again, it is an examination to determine deceptiveness. And it's not indicative of an individual's, whether their proneness to be influenced, by other factors and corruption. So, when correctional officers are within the correctional facilities, the incarcerated population is actively listening and figuring out opportunities to see if this individual, they can apply undue influences, if they can corrupt the individual, and things of that nature. So just because an individual passes a pre-employment polygraph does not mean that, unfortunately, later on, they're not susceptible
No, I got that
to any
part.
form
That's
of
easy to
corruption.
understand, sure.
And then I would also say, again, just to hats off to Director Edding and his team and everything that the agency has put in place, including the General Assembly passing a bill that actually formalizes and establishes the Intelligence and Investigative Division in statute. So I hope that is responsive to your question.
All right, welcome, Mr. Edding here. Good to see you. Thanks for coming in. Thank you.
Thank you. Senator Bailey.
Thank you, Mr. Vice Chair. Just a couple brief questions, and if this is already covered, I am extremely sorry. Having been a law enforcement officer for 30 years, big issue for me to get hired was the fact there was a whole battery of tests and background that I had to go through. One of those was, in fact, a background. You're right, but the other thing was I had to get that polygraph. And you had to pass that polygraph. And back then, if you failed one part of it, right, to be a police officer, it was a stop, right? And what you're saying is you could actually show deception on 3 parts currently.
2 parts. The 3 parts, then we won't be proceeding with the rest of the examination.
Okay, so the standards have clearly changed since the point in time that I became a police officer. So, and what you're saying is, okay, now you can show deceptive on 2 parts, you can use all the other tools in the toolbox, and you can still hire somebody.
And so when we say deceptive on 2 parts, those 2 parts, you'll get a breakdown test, and you must clear them in the breakdown in order to proceed. So all areas are cleared before the polygraph is deemed successful.
Okay, and so if I understand this correctly, and the current law is that you shall give a polygraph.
Correct. Even
And-
for candidates that don't have any signs of derogatory or deceptive background information, yes.
That's right. And so, and what you're trying to do here is you're trying to say, well, wait a minute, what we're doing, I guess, isn't working. And now you want to say, well, we may give a polygraph? We're not required?
The bill tries to give the department discretion because they're having a difficult time hiring correctional officers to fill these positions. I know you came in because of a different bill hearing.
Yes,
but
I was over.
that was the purpose of the bill.
I was
to-
absolutely over in your
Yes.
committee. You were in my committee, so I'm sorry about that.
No,
but
that's
it just
okay,
seems
but
like
that's-
I know in law enforcement we face a lot of these same challenges. The departments, many of the departments I came from, worked with, right? They face those same challenges, and it's just very scary to me to think that we would lower the standard because we were having trouble fulfilling jobs.
And I think to be clear, I don't think the department doesn't think they're lowering their standard, right? I think that standard was put in place at a time where there was obviously a lot of concerns with what took place in the Baltimore City correctional system. And since then, I think the department, and they can speak to this too, have implemented other measures to be able to have a more comprehensive look at these applicants, and therefore feel that they are comfortable with changing the requirement to be a may. It's not to say that they can't use the polygraph test, but that it is a tool if they choose to reach for it, because we're having a difficult time as a state being able to fill these correctional officer positions.
I thank you, and we can follow up, Laura, in this, because I would like to, very interested, and I'd like to know how the standards have for drug usage also. Thank you.
Thank you so much. Any other questions for this panel? Oh, on this side, I was looking this way. Sorry, Senator West, go ahead.
Thank you, Mr. Chair. Like Senator Bailey, I was over in Senator Lamb's committee and missed the first half of this hearing. So if I'm asking a question that's already been answered, just tell me and I'll look at it on the tape later on. So I well remember the situation that took place back in the Baltimore City Detention Center about 10 years ago. And the polygraph tests were instituted because of that. That was my recollection, to make sure that the officers who were being hired were people who were clean and they weren't going to contribute or perpetuate the problem. Are you absolutely certain that if we go from a shall to a may and polygraph tests are not used consistently, that you're not going to get back into this situation we had 10 years ago?
Senator, thank you for that question. Please, I will defer to Director Edding in terms of incorporating anything that I missed. However, again, as previously stated, that was approximately over 7 years ago, about 10 years for the indictments out of the Baltimore City Detention Center, and much has changed over the past 7 years alone in terms of the amount of resources dedicated to ferreting out, preventing corruption And again, I'm sure Director Edding can speak to that. Again, this is just changing it from a shall to a may in terms of the pre-employment polygraph, with the agency still continuing to use pre-employment polygraphs. I apologize, I'm like over here. But what I will say is that unfortunately, we have seen individuals who have passed the pre-employment polygraph who've gone on to be arrested for misconduct and corruption because unfortunately, at that time, the polygraph examination is merely using physiological reactions to determine if an individual is deceptive or not necessarily whether they're going to be prone to be corrupted when they've entered the correctional facilities and are around the incarcerated population.
Well, that was going to be my second question, if I can interrupt. And I remember at the time thinking, there's a way we can prevent this problem from happening, and that is requiring every 6 months or 9 months or at a random time, each correctional employee who's interacting with the prisoners to subject themselves to a polygraph test and ask them whether or not you use drugs, whether or not you've taken money, all the obvious questions you would ask to make sure that the guards aren't in cahoots with the prisoners. So this bill, as I read it, only addresses polygraph tests before being appointed to serve. What is the policy of the correctional system in terms of subjecting existing officers on a periodic basis to polygraph tests to make sure that they haven't been corrupted after their hiring?
Thank you, Senator, for that question. There is statute on the books that enables the agency to conduct post-employment polygraph examinations. So if Director Edding or his team is undergoing investigation, they receive information, the agency absolutely has the ability to utilize those tools to determine this level of deception or whether any deception exists within an existing correctional officer employee. I'd also like to note that we have put in place an analytical and technical unit whose responsibility is to identify employee and incarcerated individual fraternization by monitoring certain systems on a daily basis to determine if there's any need or any concerns arise. And in addition, we have a dedicated contraband interdiction team that conducts daily searches of both the staff and the incarcerated population, because, as we know, one of the primary indicators of corruption is the presence of contraband.
Great, okay. So I think you've answered my concern, which is not so much at the initial hiring, but how do we make sure that the guards aren't corrupted? Let me ask you one other question in that regard. Do you reassign the guards periodically so the same guard isn't dealing with the same prisoners months on end, years on end, but do you have a rotation system?
Thank you, Senator, for that question. I know that our specialized teams that conduct a lot of these searches and this analysis do rotate amongst the facilities. However, in terms of the actual correctional officer staff, it's important to keep in mind that there's also turnover within the incarcerated population, and as they, flow through the system in terms of changes in security classifications and movement among the facilities. So it's important to keep in mind that as well, that the incarcerated population is routinely transferred to other facilities, and if we know that there's a particular issue or a problematic individual who's incarcerated, that we absolutely have the authority to transfer them to another facility.
Okay, I think you've alleviated some of my anxieties. Thank you very much.
Thank you, Senator.
Senator Sidnor.
Thank you very much. A few questions. One, I'm curious, the department submitted a letter of information, but just from the number of you who are here, it seems as if, it should be a letter of support, and I'm just curious, was there some reason why it was letter of information rather than a letter of support? Because it seems this is like a departmental, bill in essence. I'm asking you all.
I think it's Chief Sessa probably could
Okay.
answer that.
Okay, thank you, Senator, for that question. Again, the agency is here to provide information on what the current hiring process is and what we've experienced over the past 7 years to assist the committee in terms of its deliberation on this particular bill.
So you have no position one way or the other?
Just to provide informational testimony at this time,
So you have
Senator.
no position one way or the other? I mean, I read this letter of information, and it seems to me it's a letter of support.
I appreciate that question, Senator.
Thank you. I think we got it. I really appreciate it.
Okay.
Do you have other questions, Senator Sidnor?
I do.
And I apologize, I have to run to finance because they were calling me down there for another bill. But thank you.
Senator Carter had asked about by introducing discretion into this, that you might have an issue of discrimination, and I'm curious, how would one ensure that the test, if given the discretion rather than being mandated, would not be used in a discriminatory manner?
Thank you, Senator, for that question. So our Human Resources Services Division would promulgate and draft regulations that would have to be approved by the Office of Equal Opportunity, as well as an Assistant Attorney General. And those regulations would come before the AELR Committee for legislative review and input. And so through those multiple layers and multiple processes, we would ensure that there would be a systematic approach to when the pre-employment polygraph would be utilized, to ensure it would be equitable and fair and not discriminate against anyone.
Okay. And the final question that I have, I've been listening to some of my colleagues and referencing the correctional officers and listening to how you have all been referring to correctional officers, and you're using the term correctional officers, correct?
Oh, yes, Senator.
Not
Correctional
guards,
officer.
right?
We absolutely refer to our correctional professionals as correctional officers. CO1, if you want to, we always want to put an acronym on everything, right? So a CO in short.
Right, and it just caught my attention. I remember when I used to clerk at the court, they were very prickly over being called guards rather than correctional officers, so thank you.
Thank you, Senator.
Other questions for this panel? Well, I too want to say thank you not only to the department, which is in front of us frequently, but also to our friends at AFSCME, which is in front of us less frequently, usually in front of the Budget and Tax Committee. You've heard here today, but being a correctional officer is one of the most difficult jobs in the entire planet. And so we thank your members specifically for everything they do to help keep our community safe, and really appreciate the hard work that they put in and day out. It's a really tough job. Thank you, everyone. That concludes the hearing on that bill. We'll next move to Senate Bill 842. Senator Benson, I know you've been waiting very patiently. Senator Benson, I'm sorry, I'm having difficulty seeing you, but you're up next, Senator Benson. Come on up. Senate Bill 842.
Good afternoon, Mr. Vice Chair and esteemed members of the Judiciary Proceedings Committee. I am here to present Senate Bill 842. In 2025, I'm sorry. Yeah, in 2000, well, 10 years ago, I was called in my office downstairs, or is it upstairs? Here on the second floor. I was called and told that one of my students was incarcerated in Denver, Colorado. As most of you know, I am a retired school principal. And when they told me who it was, I thought about this student. And when they explained to me what was going on, that he was involved in a murder in Denver, I thought about him as my student at John Bain, and I followed him through middle school as I did most of my students, and made a decision to travel to Denver, Colorado to see what was going on with my beloved student. Now, people say, now, that was not your child, but yes, it was. It's 2005 is when I made this decision. And after conversing with this youngster and finding out the circumstances that were involved, in which he was involved in a murder, I made a decision after he had served 22 years of his life incarcerated that I would do something about the problem. And for 5 years, I traveled back and forth to Denver, Colorado, worked with a number of people, trying to ensure that once he was given a second opportunity, he would return back to the state of Maryland. We would mentor him, throw our loving arms around him, and help him to make a transition back into society. We even raised money to send him to college while he was incarcerated in Denver. We did a lot of things to help this youngster. After 5 years of our going back and forth, going to the legislature to change the laws, going to Capitol Hill, going to the Supreme Court to change some laws at the Supreme Court, we were very successful in getting him released because he was sentenced at the age of 16 to life without the possibility of parole. But because we changed the law in Denver, Colorado, we were able to get his release, put him on probation, and we brought him back to the great state of Maryland. We got him a little job, and we began to mentor him and counsel him. And I want you all to know that he went to college, did very well, never caused any problems. And he told us all that he had turned the corner when he was 21, at the age of 21. He said, I turned the corner and recognized that, first of all, I should not have been with a crowd. And number two, I'm extremely remorseful for what I did. We also were able to get counseling to help him to work through the problems that he was suffering, even as a child. So I knew his background. And so I made a decision to mentor him, and right now, he has moved to New York. He's got an excellent job and found somebody who would have him and got married, and he is doing wonderful. Bought a house, and he's up in Schenectady, New York, in all of that snow. I'm still mentoring him and working with him. And we're talking now about a young student who was given a second look. And so I am here this afternoon to present to you this bill, Senate Bill 842. Because as I look at my students and as I look at youngsters all over the state of Maryland and even adults, we tend to paint all of our adults and children with the same brush. Some of our children and some of our adults are incarcerated because they did not have the financial means to even fight their case. In the case of this youngster that I'm talking about, when he went to court in Denver, the attorney came back and told us that she was very remorseful because she did not have the proper tools to really represent him. And that, of course, did not sit well with me at all after he had served 22 years of incarceration. Currently, the United States leads the world in incarceration of its citizens, with 2 million individuals currently in U.S. correctional facilities. Additionally, prisoners have been about 500% increase, have seen a 500% increase through the last 40 years. Amendments and changes to laws and policies used for sentencing, not changes in crime percentages explain the vast majority of this increase. African Americans are being incarcerated in prison across the nation at almost 5 times the rate of their white counterparts, and Latino individuals 1 in 3 times as likely to be in prison than non-Latino whites. This legislation ensures the fairness and justness of the imprisonment system in the state of Maryland. Unfortunately, Maryland is one of 12 states where more than half of the prison population is African American. Per the ACLU, the average yearly expense of imprisoning an elderly individual is $72,000 a year. And the population of older detainees in Maryland is substantially growing. This continues to create an increased financial burden as more of the detained population becomes elderly. This bill's purpose is to permit an individual serving a term of imprisonment to appeal to a court to alter or decrease the sentence under specific conditions. This does not mean that you open the floodgates and everybody is sent home. No, no. For the petitioner to have the choice to seek appeal after their conviction, they must first have completed both the accompanying impediments, served 20 years of the sentence without the utilization of diminution credits, or the equivalent of 25-year sentence with the utilization of diminution credits. This bill will also allow the victim of the crime or a representative of the victim of the crime to be granted the ability to present their objection to the petition's appeal of an altercation or alliteration or reduction of their sentence. In conclusion, this bill will assist with lessening the current financial burden that mass incarceration creates and that so many individuals face, while also guaranteeing that we maintain fair practices and empathetic sentences in our courts. I would ask that you please give this bill a favorable support. Senate Bill 842.
Thank you, Senator Benson. Before taking questions, let's get your panel up here. Ms. Elizabeth Hilliard and Ms. Monica Cooper.
You all know that I have to go back downstairs because we're in the process of voting.
Would anyone object?
I will stay just a little while.
Okay.
If you all don't mind, would you please excuse me? I know that you all enjoy seeing my beautiful face, but I'm going to have to leave you all in a little bit.
We do indeed. Whoever would like to go next.
Good afternoon. My name is Monica Cooper. I am the Executive Director of the Maryland Justice Project. I am a formerly incarcerated woman who served more than a decade behind a wall, and I will tell you, I didn't leave the same. After about 3 years, 2 years, 4 years, I wasn't the same person. And I sit here now as an elected official, 40th District Central Committee person. I'm sure many of you have been on Central Committee at a time or two. Well, I was fortunate to gain the elections, the votes of my peers. I borrowed money from my grandmother for signs, and here I am. Also, I'm a college graduate, and I run my own organization. But I guess I'm saying all that to say is that people should get a second look. We have some bureaucratic things that say, okay, you put your, within 90 days, you put your modification in. That sometimes it's just not enough time to actually give a person the opportunity to think about the things you've done, to think about how you could change your life around, to benefit from therapeutic programs on the inside if you have them, to benefit from those things. So if a person has sit for 10, 15, or sometimes 20 years, I can tell you from my own experience that I wasn't the same person. And not only that, but my case manager could tell you, the people who I went up in front of parole could tell you, the person that I worked for in the shops could tell you, the correctional staff, which one of them I actually saw here today. She could tell you that I wasn't the same person. So when you have folks that can kind of chime in and said, well, this is not the person that they were 10 or 15 years ago, maybe you should give them a second look. So that's all I really wanted to say is that people do change. I know we're in a climate right now where there's a lot of stuff going on in the state, but there are some people who have come home and they own businesses. I started a solar energy company about a month ago. So some of you guys will hear from me. I'm gonna need some help. But we are ambitious and we want to pay taxes and we want to get home and we want to do the right things. Some people do learn their lesson. So to just write everybody off just like that is just not fair. And it's not fair to us. Instead of paying $40,000 a year, you get to create a tax base. My taxes are high. I said it to you a lot. I'm paying taxes. I don't mind paying into this tax base, but I think we can, think conservatively in terms of monies and amount of monies that you can save rather than having people behind a wall who can actually be out here doing well. I guess that's it. I can't believe y'all didn't say my time is up. I should just keep going just because. Thanks anyway.
Thank you so much. Go ahead. Just for, the reason we have people at the podium is just because of where the camera is located. So if it didn't happen, no worries, but
Okay.
thank you.
I will take the podium then. Thank you, and I see that you made sure to make sure my time is running, so I appreciate that. Thank you, Vice Chair, members of the committee, Elizabeth Hilliard with the Maryland Office of the Public Defender. We want to thank the work that the General Assembly did in passing the JRA last year. It was a great step forward. This is the next necessary step. Allowing people who have served incredibly lengthy sentences an opportunity to petition for modification makes sense and is critical for 3 reasons. First, people change. Biologically, neurobiologically, through work, effort, and the enormity of serving a prison sentence, a person who walks through DOC's doors is never the same person who leaves. Second, the cost of mass incarceration to Maryland in both humanity and finances is abominable. We cannot continue to pay to incarcerate non-dangerous individuals. It is too expensive for the persons who are incarcerated, for their families, for their loved ones, and it is too expensive for Marylanders as a whole. Finally, I work in the Office of the Public Defender in post-conviction. I represent people who have served sentences longer than I have been alive. I can tell you that rehabilitation is possible, and it is critical to the way that we analyze our criminal system. For these reasons, we urge a favorable report on Senate Bill 842. Thank you.
Thank you so much.
Thank you.
Senator Carter.
Thanks, Mr. Vice Chair. Just briefly, I just wanted to, I'm glad you stayed, Senator Benson. I wanted to thank you for bringing the bill. Your story is always very, very touching, and I can't hear it too many times because it's a great reminder about injustice and how prevalent it can be to impact somebody's life. I just have a general question. So I think the bill is a good idea. It's always troubled me that a person gets 90 days to file a motion to modify or reduce a sentence, and then it's got to be heard within the 5 years, and then outside of the post-conviction, which is limited to, the effective system of counsel issue, there's really nothing else except what we created last year with JRA for the juvenile offender, or the juvenile, person that's convicted. My thought, and I heard what you said about the lengthy sentences, that's terrible. I've always thought we should do something to expand the 90-day limitation on the filing of that modification of sentence. And then in the early days, until some years ago, Ms. Hilliard, it's for you. So until a few years ago, we didn't have that five-year limit on when that had to be heard. And so I've thought we should do something to expand it generally. So I kind of wanted to get your thought. I know you like this bill, but even outside of this bill, Do you think that there is a need to expand that 90-day time requirement and that 5-year, window that the person has to be heard?
Thank you for your question, Senator Carter. You've heard me say this before. I'm going to give you a very lawyerly answer, which is it's complicated and it depends. I certainly understand that part of the reason behind imposing those limitations is to afford some finality and some sort of certainty to victims. And I understand that it also sort of is a way to ensure that the judge is sort of put on notice that a motion for modification may be coming close in time to the sentencing. I think that there are many ways to approach what I would call sentencing reform or second look opportunities. This is one way. Changing the 90 days is another way. I think that this bill is particularly important and geared towards persons who are sentenced to long offenses who 5 years is maybe less than a quarter of the time that they've served. It's certainly not going to be sufficient to give the judge the opportunity to see their progress. There are certainly cases where 90 days or 5 years does make sense. For example, if someone is sentenced to 6 years or 7 years or even 10 years maybe that 5 years is a good middle ground. And I think that there are numerous ways to make a more workable option to permit a court to have authority. For example, maybe perhaps with a sentence that would put someone into local detention centers under 18 months, that could have a 90-day limit, and then the rest of the sentences could have the 5 year. I could see a graduated plan working very well to sort of tie to the person's sentence, but this is a good opportunity and a reasonable, I think, middle ground, accounting for both certainty and the opportunity to have a reconsideration.
Are you aware of any other states that either do the proposal under this bill or something similar to what you discussed as the graduated system, which could provide greater opportunity for more individuals?
Off the top of my head, I'm not sure. I know that there are numerous states that have enacted second look statutes that apply in various circumstances and to varying ages of populations. I can get more information and get it to you, though.
I'm sorry.
You just like red flashing lights. All right, seeing no further questions, thank you both very much.
Thank you.
All right, so now that concludes the testimony for the proponents of the bill. We'll now switch over to the opposition panel. So is Kirk Wolfgang? You are. William Katz. Yep, Billy.
Good afternoon, ladies and gentlemen. My name is Kurt Wolfgang. I'm the Executive Director of the Maryland Crime Victims Resource Center. For over 40 years, we have dried the tears and held the hands and fought the legal battles for the crime victims of Maryland statewide. Before you incline to favor this proposal, I ask you to do your very best to see things from the crime victim's perspective. And that's a very dark place to try to take you. Descend with me into the despair at a level that few have ever tried to describe. English words fail to reflect the agony and the fear and the hopelessness of these crime victims. I'm going to, you have my written testimony. I'm going to skip forward a little bit to get to some of the examples that I would like you to try on to see what they would be like if you had to go through them or your family had to go through them. So all of these happen to our people that we've represented over the years. So imagine you're 8 years old and you're in the bed of your mother at home because your uncle's come to live there and you don't understand why, and his wife is very angry about it. So you ask your mommy if you can sleep in her bed that night. During that night, you wake up to the sounds of your mother shrieking in agony and fear as as your aunt stabs her again and again and again and won't stop until all of her blood is in the bed and on your pajamas. Imagine that you learn on Good Friday that your firstborn daughter, the one who was to graduate next month with honors, that daughter who has been your best friend, was abducted and raped and sodomized repeatedly. Please read the testimony that I provided. It will give you the idea and the perspective that these crime victims go through. They do not want to be called to court repeatedly to try to ensure that justice is done. And I appreciate your time, and I'm available if questions are forthcoming.
Mr. Chairman, members of the committee, my name is William Katzoff. I'm an Assistant State's Attorney from Anne Arundel County, here on behalf of the Maryland State's Attorneys Association in opposition to Senate Bill 842. Let me first of all point out the fact that under current law, current rules, a person can file a petition with the court within 90 days after having been sentenced. If a person is sentenced in the circuit court for less than 2 years, it would have to be through the a 90-day period to file a petition for reconsideration with the sentencing judge. There is a provision for 2-year sentences or above. You can file for a 3-judge panel. The point is that that particular provision in our rules allows for a defendant/petitioner who perhaps as a result of a trial in which tensions were pretty high would have an opportunity to have that sentence reviewed by either a sentencing judge or a 3-judge panel, okay, in a perhaps somewhat more dispassionate environment. The tensions may have been very high. It may have been a very, very difficult trial. Emotions were sort of running amok, and in order to try to create a more suitable atmosphere, it gave the judge an opportunity to correct a sentence that perhaps he or she would not have otherwise given. The law was changed some years ago to allow the sentencing judge who has been the recipient of a petition for reconsideration to hold that sentence for a period of 5 years to maintain control over it. After that, it becomes the responsibility of the parole commission. What this bill really does is essentially take a single sentencing judge to fill the role of the parole commission. The parole commission is charged with the responsibility to determine how well or how poorly that person has progressed through the correctional system during the course of his or her commitment. I don't think we should substitute the judgment of a single judgment of the parole commission by enabling a single circuit court judge to basically trump the parole commission. I would urge this committee to give the bill an unfavorable report.
Wolfgang?
Yes, sir.
Yeah, I'm sorry. Haven't seen a lot. So listen, I just want to thank you for coming and testifying. I mean, it's sad that, you know, Virginia Roper's days are over, and unfortunately, the cries of the victims just don't ring very hallowed in these halls anymore. These are the days of injustice that's been foisted upon murderers and the like. That's what we listen to, and I'm sorry to say that your folks, we just can't hear them anymore. Thank you very much for coming in, sir.
Sir, just my comment back to you is I understand that we're all concerned about injustice in the sense of imbalance, racial imbalance and things of that nature. Our organization represents 70% people of color who are the victims of these crimes. I think it's seldom mentioned that there is another dynamic statistic, and that is who's the victims of these crimes.
Never mentioned. Thank you.
Mr. Chair, Mr. Wolfgang, just a quick question for you.
Yes, ma'am.
Again, thanks for coming in, and you testified about the victims that your organization represents. I disagree, though, with Senator Casserly. I think that we consider all sides of the issue. But one of the things that struck me is that you are aware that some crimes and some felonies and some sentences, people are serving sentences for crimes that don't necessarily involve a victim. They could be in there for money laundering or racketeering or possession with intent to distribute or distribution. You know, it's not always rape, murder, and those kinds of things where there's a specific identifiable victim.
Yes, Senator.
And then also, when we considered the legislation that we passed last year, we had a great deal of data that showed that over time, oftentimes victims, through time and through feeling like there was some modicum of justice served for them, that they don't necessarily feel this kind of vindictiveness where they want to see the initial culprit, rot in jail for the rest of their lives. Haven't you come across that with some of your victims at times?
So let me answer the first part of that first, and that is nonviolent offenses that you're referring to. And frankly, I think I couldn't see, but I think it was your comment earlier about the 90 days to file. And I'm with you on that. I don't think there ought to be a 90-day limitation. I do think there ought to be a 5-year limitation, but not a 90-day limitation. That's just gamesmanship on the part of the courts, if you ask me. I will say that almost 100% of the time, that motion to reconsider gets filed within the 90 days, but when it doesn't, it's just gamesmanship. Having said that, the nonviolent offenses, I don't think many of them are going to be at issue with this bill, because you're not going to find, in most instances, someone in prison after 20 years or 25 years on one of the nonviolent offenses that you referred to. And in terms of, I don't characterize it as vindictiveness. Please, if you do nothing else, I would appreciate it if you would read the testimony that I've sent. Those are not my comments. They are the comments of our clients who have come together on this issue almost unanimously in their opposition, and it's been over a 2-year period as we face this bill, previous bills, and other situations where the court tried to do it by rule. We came together. I was astonished at the unanimity of our clients on the issue, and it was across all racial and gender divides as well.
Well, I'll just say this. I assure you and everyone else that every senator on this committee takes the rights, the needs, and the desires of victims to heart, and that's why sometimes this work is inglorious, because the reforms of the last few years put us into a place where it's not always easy to talk about and are meant to correct past injustices and to rebalance a system. So I'd have to agree with Senator Carter with that. But thank you very much, and thank you for all your work.
Thank you, sir.
All right. With that, that'll end the hearing for Senate Bill 842. We'll now move on to Senator Carter. Are you good to go? Okay, we can start off with Senate Bill 774. Okay. Senate Bill 774, Senator Carter.
Mr. Chair, members of the committee, I'd like to bring up my panel, which is, again, Elizabeth Hilliard, Lila Meadows, and Yvette Emanuel. Yvette. Chairman Smith and members of the Judicial Proceedings Committee, this bill is really a cleanup bill that corrects the legislation that we passed last year, getting the governor out of parole, kind of through a glitch or I think an oversight. We did not actually have that legislation apply to medical parole, and so all this bill does is include medical parole in the giving them the opportunity to get parole by the commission, as does everyone else, without having to have the governor rule. And so Senate Bill 774 completely removes the governor from the medical parole decision-making process, repairing a technical oversight in Senate Bill 202 from the 2021 session. With the passage of Senate Bill 202, the legislature intended to remove the governor from all involvement in parole verdicts. This bill does that. In 2021, not only did we vote to reform the parole process, but we overrode Governor Hogan's veto of the bill later that same year, further solidifying our stance. Until the passage of this bill, Maryland was one of only 3 states that still involved the governor in the parole process. This reform exclusively left the power to review and grant parole for life sentences to the Maryland Parole Commission, a nonpartisan board composed of law and social services professionals. This bill addresses medical parole. I believe that based on our vote in 2021, we should also leave the absolute power to review and grant medical parole to the aforementioned commission. This bill would altogether remove the governor's authority to approve, disapprove, or consider the parole commission's decision in medical parole cases. Medical parole was established in 2008 because we recognized that incapacitated inmates pose no threat to society. Having served a certain amount of their sentence, individuals with extreme mental and physical health conditions were deemed eligible for parole consideration. It was not until 2017 that we carved the governor a role in the process. Out of the 2,000 people serving life sentences in Maryland prisons, only 34 individuals applied for medical parole in 2018. This bill removes whispers of partisan politics from deciding a convicted person's fate. Senate Bill 774 furthers our intent. Maryland governors, as we know, have notoriously disproportionately adopted a tough on crime mentality, resulting in disproportionate sentences for Black and brown people, which we've dealt with throughout the course of most of last year and with the bill from last session. When we passed Senate Bill 202, I keep wanting to say 2002, I'm sorry. When we passed Senate Bill 202, I do not believe the General Assembly intended to bifurcate the determination of medically eligible parole inmates between parole commissioner and the governor. The crossed file of this bill, House Bill 920, had a seamless hearing on February 22nd in the House of Delegates, and considering our prior actions and the limited number of opponents to this bill, I would humbly urge a favorable report.
All right. Good afternoon, Chair Smith, Vice Chair Wallstreicher, members of the committee. For the record, my name is Yanetta Emanuel, Interim Public Policy Director with the ACLU of Maryland. As Senator Carter mentioned, last year the General Assembly voted to remove the governor from the parole process for persons serving life sentences. Our clients, their families, and loved ones are extremely grateful to you all for passing this important bill. I'm here today in support of SB 774, which is a real simple bill that seeks to fix an error in the bill that passed. It was clearly the legislator's intent to remove the governor from all parole decisions for individuals sentenced to life in prison. However, the section of the code pertaining to medical parole was omitted from the bill draft, resulting in a situation where only medical parole cases now require a gubernatorial action. SB 774 would simply correct that omission. The need for a parole commission to be able to act expeditiously is arguably most critical in those cases where the parole candidate is seriously ill or dying. For the foregoing reasons, and for the reasons you'll hear from my colleagues, the ACLU of Maryland urges a favorable report on SB 774, and I'm happy to take any questions. Thank you.
Good afternoon. My name is Lila Meadows, and I'm a clinical faculty member at the University of Maryland School of Law, where for several years I've represented lifers in the parole process, including individuals who are seeking medical parole. I think that Senator Carter and my colleague, Ms. Emanuel, have pretty well covered what this bill is about. Again, this is a technical fix that fixes a drafting oversight in Senate Bill 202, which we're grateful that this committee and the Senate passed last session. I just want to say it's a technical fix. It's a perhaps a small problem, but with a big impact. You heard testimony either last week or the week before on Senator Heddleman's geriatric and medical parole bill about some of the individuals who are impacted, who meet the standard for medical parole. We're talking about people who are terminally ill, who are truly incapacitated, where time is often of the essence. Requiring the governor to review these cases, often in my experience for my clients, really slows down the possibility of release. It costs people who are terminally ill precious days, weeks, and frankly, when the governor gets involved, many months before that they can be released and receive outside medical care and spend what little time some of them have left with family members. And so I would urge you to pass this bill. Thank you.
Good afternoon again. Elizabeth Hilliard with the Office of the Public Defender. I believe that Ms. Emanuel and Ms. Meadows covered, and Senator Carter covered the intricacies of this bill, so I will speak very briefly to the failings of the medical parole process and what it's like to represent someone who is waiting on gubernatorial approval to die at home with their family. This past summer, I represented a person who was in the JCI hospital. If you have never visited a prison, or if you've been to a federal prison, which unfortunately is much nicer than a state prison, I would advise you to go to JCI and to go to the hospital wing there. It is one of the most harrowing and truly heartbreaking places you can be. I went there this summer, dressed to the nines in my COVID protection gear, to meet with a client who had no opportunity for release other than medical parole. He was bedridden. His doctors, his social workers, his oncologists, his family contacted me frequently to let me know his passing was imminent. He was alone in a hospital bed, incapable of moving, incapable of feeding himself, incapable of getting released from prison. We had a hospice care facility set up, ready for him. We had wife and family and friends who wanted to see him before he passed, but we couldn't get gubernatorial approval in time. I'm a pretty emotional person. I'm happy to admit that. I think you can be a lawyer and also be emotional, but I will tell you, I have never cried so much as I did when I got the phone call letting me know that this client had passed away. By himself, without his friends and family around, scared and alone. This is a simple fix to improve a very big problem. Thank you.
All right, thank you all very much. Questions from the committee? Seeing none, thank you all very much. So let's do, can we have Monica Cooper? And I think that's it, your last one.
Okay, I'm standing up this time. My name is Monica Cooper again, and thank you for hearing me. And I do just want to say with my 2 minutes that I'm always so thrilled that I get a chance to actually come and speak to elected officials. I wanted to ask for a favorable vote on this bill, Senate Bill 774. I guess because for some of the reasons that I spoke of before, I think it is fiscally responsible as we continue to balloon our Department of Corrections budget. There are some ways that we can decrease prison population, and there are some ways that we can save money. The amount of money that it cost to house Barbara Hampton was in the millions. I talk to Barbara Hampton on the phone often. She suffered from cancer, and I have a whole litany of all the amount of money and the treatment that it cost. It actually cost millions of dollars to house her. Unfortunately, Barbara Hampton died in prison, and she was one of those ones that was terminally ill and just wanted the right to die at home. So I just wanted to bring our attention to how much it's costing the state to house these individuals that are no harm to the community. And upon release, I mean, they go to places that can care for them. They go to places that are more fiscally funded to care for them, and it won't cost the state monies the way that it's costing them now. And it is a technical fix. Fix it. Thanks.
Thanks, Ms. Cooper. We're thrilled you're here as well, so thanks for coming down. All right. With that, that'll conclude the testimony and the hearing for Senate Bill 774. We'll now move on to Senator Carter with Senate Bill 776.
Thanks, Mr. Chair. I'd like to bring up my panel, which is Anna Rodney, Kimberly Haven, Tanya Kane. So members of the committee, I'm really thrilled that advocates brought this bill to me because I'm truly proud to sponsor this bill. It really seems like both a common sense measure and something that we can really do good to help families that are dealing with our carceral system. Senate Bill 776, the Prevention of Forced Infant Separation Act, gives infants born to incarcerated mothers in Maryland the head start they need to live healthier and happier lives. In Maryland, most pregnant women go into labor while incarcerated spend less than 48 hours bonding with their infant before the newborn is taken away and either placed in a secondary caregiver or in foster care. This is because there currently exist no accommodations for mothers to remain with their infants during the tenure of their incarceration. Not only is this forced separation of mother and infant inhumane, but it presents a significant public health issue. Research shows that an infant's first year of life is one of the most important. When infants are prevented from consistent bonding with their mothers, there can be lifelong developmental consequences, such as an increased risk of post-traumatic stress or substance abuse in adulthood. The mothers are more likely to experience postpartum depression, extreme powerlessness, grief, and feelings of detachment. In 2021, Minnesota passed legislation known as the Healthy Start Act. It became the first state in the country to prevent the practice of forcibly separating infants from their incarcerated mothers. This bill is based on the Minnesota law and expands upon a bill sponsored that we all remember from 2020 by Senator Mary Washington, which authorized the Commissioner of Correction to operate a pre-release unit for women within the Division of Corrections. Specifically, this bill would provide pregnant women in the custody of the Department of Public Safety and Correctional Services with pre-release status. The option to relocate to the pre-release unit throughout the duration of their pregnancy and remain with their infants up to 1 year postpartum. For pregnant women who are not eligible for pre-release status, they will have access to liberal visitation with their infant. In both facilities, fathers or appropriate secondary caregivers would also be permitted increased visitation with the infant. This would better facilitate the infant's transition into the community. In addition, Senate Bill 776 will create the Healthy Start Program. The Healthy Start Program is an initiative that will use evidence-based interventions developed by healthcare professionals to ensure well-built bonds between families and infants. Although incarcerated women are at higher risk for substance use disorder, mental illness, and poverty, research shows that the trauma to an infant caused by forced separation outweighs the consequences of these risk factors to the infant. Instead, experts in child development advocate for interventions like this Healthy Start program because it connects incarcerated mothers with needed resources to form lifelong bonds with their children. Such interventions have also been proven to cut recidivism rates of participants in half and increase the likelihood of mothers retaining custody of their children post-incarceration. The Prevention of Forced Infant Separation Act is evidence-based legislation that recognizes the right of every person to parent their children. As such, I would urge a favorable report. Thank you.
Was there a question?
No, go up.
Oh, okay.
Don't rush to the podium all at once now.
Okay.
All right, let's go.
It's been so long since I've been here, I forgot how the place works. Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Kimberly Haven, and I am here today on behalf of Reproductive Justice Inside, our collaborators, our supporters, and our allies. And we are here in support today of Senate Bill 776. When I came in here, I had like facts, I had figures, I had really cool things that I wanted to share, but I want to pivot now for a minute. Imagine carrying a life inside of you for 9 months, and then you give birth. You've taken care of this baby throughout this 9 months. You've done right. You've eaten right. You've exercised. You've taken your vitamins. You've done everything to nurture this child. And then they place the baby on your chest. The sweetest smell in the world, I think every parent would agree, is the smell of a newborn baby's head. Infants know at birth their mother's smell, touch, voice, taste. Now imagine 48 hours later, you're transported back to prison and your baby goes elsewhere. That maternal bond is severed. The number of issues this raises and the trauma that it causes is tremendous, as Senator Carter just kind of went through a couple of them. Not being allowed to breastfeed, not being allowed to express your breast milk to provide for your child, no options to bond, and the list goes on. The trauma to both parent and infant will play out for years, if not generations. SB 776, while a forward-thinking effort, is actually a tremendous recognition of the importance of this maternal bond and the right to parent with dignity. 776 is good legislation. It is good policy, and I urge a favorable report. Thank you very much.
Good afternoon. I'm Tanira Kane. Thank you for allowing me to come, Chair and committee members, and thank you, Senator Carter, for allowing me to testify on this Bill 776. Before I tell you who I am professionally, let me tell you who I was. 18 years ago, I was told and treated like there was no hope for me. I have been on the streets of Annapolis for 20 years as a drug addict, diagnosed mentally ill, homeless, and was having children as a result of rapes and prostitution. Rightfully so, they were removed from my care. March 15, 2004, I ended up in prison again. My 83rd arrest, my 66th conviction, and I was pregnant. And I knew that this time I was going to be successful for one thing, and that was going to be suicide, because I could not stand yet again another baby being snatched from my arms. I was able to go to an alternative program for women that was in prison. In this program, I was able to form a secure attachment with my child. I was able to breastfeed, and of course, I'm almost 18 years clean and sober. Today, I am an award-winning film producer. I produce film and television. I'm known in 60 countries for my work changing systems of care and how to treat trauma survivors. I have days named after me by governors and mayors throughout the United States. I have trained providers in all 50 states, helping them to change their systems of care to get better results for the people that we serve. I own 7 companies, 2 of them are global. And my daughter, who is 17 years old now, she's thriving. She went to Key School up until high school. Now she's in Annapolis Area Christian School doing amazing. The best care that we can give a baby is a mother's care. So that's why I'm here to support Bill 776. Always remember, where there's breath, there's hope. Thank you.
Well, Ms. Kane, you gave me some inspiration for the end of this day, so I appreciate that. And thank you for your testimony, and thank you for sharing your story. That's great. We'll go on to questions from the committee. Senator West, you're up.
Thank you, Mr. Chair. So as I look at this bill, if I can find it now, the mothers to be incarcerated in an institution which hasn't been built yet. How are we going to deal with that?
Well, you know, we're in the early stages of that. We had a bill earlier this year that was asking us about, you know, what are we doing with the funding? It's my understanding that based on money in the budget this year and the plans for the next couple of years, we're looking at about 2 years between now and when that should be up and running.
Well, the information from the Department of Public Safety says that the governor has put into the 2023 budget $150,000
Yeah, that's not much.
to hire a project consultant. And they're predicting that it's to fulfill the capital requirements will take 3 to 4 years if the budget is there to support various steps along the way. And this bill takes effect later this year. So what are we going to do? I'm supportive of the bill, but we can't incarcerate women in an institution that hadn't been built.
I think we need to encourage the governor to put more money in the budget to speed this process along. But outside of that, I mean, I guess, you know, we have to make do with the best we can until we have this facility up and running.
Okay, so you would accept an amendment that
Yes.
says we'll have to make do as best we can until the building's
No,
built?
the amendment, I mean, I think the amendment would have to say that, you know, the bill is contingent upon this, access to this facility, or something comparable. If we don't have the actual pre-release facility, perhaps there's other accommodations that could be made.
Okay, thank you.
All right, further questions from the committee? Seeing none, thank you very much. We'll have to bring up the next one. I get 2 more
Thank
witnesses,
you.
Senator Carter. All right, thank you. All right, we'll bring up Natasha Califani and Olivia Spasia and Monica Cooper.
Good afternoon, members of the committee. My name is Natasha Califani. I am an attorney at the Office of the Public Defender in the Parental Defense Division. In the Parental Defense Division, we help parents whose children have been removed from their care and placed in foster care to regain custody of their children. We support this bill because it is another means to help families remain together and/or reunify if they are separated. This bill treats incarcerated women and their infants like they matter and has the potential to keep families together. If a woman who gives birth, so I really just want to explain what happens when a woman who is incarcerated gives birth and she doesn't have any family to care for her children. That child is placed in foster care. And once in foster care, the court has a statutory timeline of 15 months before they have to consider adoption. When that child is an infant, generally, courts do not wait 15 months before terminating the parent's rights. Generally, that child will have 6 months, and then the plan will change to adoption. In a case where the mother is incarcerated, while she is able to attend those hearings, the Department of Social Services does not have any obligation to offer her services. That means that she attends a hearing to hear updates on her child and how her child is doing. She does not get to visit with her child. She does not get to have very much input, and she does not get any services to try to reunify. We believe that this bill is important because it changes that for incarcerated women. It allows them to remain in contact with their child for up to a year, and it will also provide them the services that they need so that if for any reason they have to be separated from their child, they can quickly be reunified. And for those reasons, we would ask a favorable report.
Good afternoon, committee members. My name is Monica Cooper again, the Executive Director of the Maryland Justice Project. I guess I would first start off by asking for a favorable report. The other thing is I wanted to because I am the lead person on that pre-release bill, and what I wanted to say is, even though our current governor has attempted to veto this economically, we are going to be successful in getting this money in the budget. We have been working overtime, meeting with the Finance Committee members, and I'm almost confident that we're going to have the monies in the budget to get this started sooner than predicted by Public Safety and Corrections. And please remember that term, economic veto. We can't let it happen. The other thing I wanted to say is that this program has a proven person right here in Ms. Tonia Kane. This is a program that has worked. This is a woman that shared with you that right here in the Annapolis area, she has had many convictions and many times being arrested. But it was that child and that program and bonding with that child that changed her life. And I believe that we have women right now who will be able to follow that same path if it is the will of the state. Thank you.
Good afternoon, Chair Smith and members of the committee. My name is Olivia Spicassi, and I'm here on behalf of the ACLU of Maryland to urge a favorable report on SB 776. Despite the massive increase in the number of incarcerated women over the past 30 years, adequate attention has not been given to the specialized needs of women who are incarcerated. Nowhere is this more obvious than in the treatment of pregnant and postpartum mothers. As mentioned by the panel, the forced separation of infants leads to a variety of adverse health outcomes for both the baby and the mother. When babies are forcibly separated from their parents just days after birth, there can be lifelong developmental consequences. The incarceration of a parent, regardless of the age of the child, has been connected to increased risk of substance abuse, teenage pregnancy, social isolation, development of learning disabilities, financial hardship, and involvement in the criminal legal system. These hurdles, coupled with the long-lasting cognitive, emotional, and psychological effects of separation on newborns, places an immense burden on these vulnerable children. Additionally, because of existing racial disparities in incarceration, these harms disproportionately affect Black and brown children. As Senator Carter noted, mothers separated from their newborns are more likely to experience postpartum depression and feelings of detachment after forced separation. It's important to remember that some of these mothers will maintain or reacquire their parental rights and act as caregivers to their children upon release. However, the harms of that initial separation pose great risks to maternal competency and attachment behavior. In order to mitigate harms to both mother and baby, we must allow the two to have as much contact as possible with one another during this critical period. For the foregoing reasons, the ACLU of Maryland urges a favorable report on SB 776. Thank you for your time.
Excellent. Thank you very much. Questions from the committee? Seeing none, thank you all very much. And with that, I believe that will conclude the testimony and the hearing for Senate Bill 776. We'll now move on to Senate Bill 783, and I'll ask Senator Lee if you could take the chair. I'll ask if, I know we have a lot of witnesses on this bill, but I'd like to have Suhani Chantila, Matt Littleton, and Sonia Zaja up to the panel if they could, please. How are you? I'm sorry? Cool. Hey, how are you? Hey. All right, actually, I see the vice chair is back there now, so it's up to you. It's up to you, All right, good afternoon. Senator Smith here to testify on behalf of Senate Bill 783, the Environmental Human Rights Amendment. So very simply what the bill does is that it's a proposed constitutional amendment, so if we pass it here by an overwhelming majority, it'll go to referendum in the next general election, and if ratified, it'll go into our Constitution. It essentially does this. It says that each person, as a matter of human dignity, has a fundamental and inalienable or alienable right to a healthful and stable environment. The state, as a trustee of Maryland's natural resources, including its air, lands, water, wildlife, and ecosystems, shall preserve them for both current and future generations. So, and then it goes on, it says, every person deserves a fundamental right to healthy environment and a healthful environment and clean air. So this is not a novel concept. 7 states have done this across the nation, and I'll talk a little bit more about how it's been construed and its construction, because there's a lot of concern that it would create a private right of action and that there would be a flood of litigation. But this would be construed similarly to the rest of our Declaration of Rights, and in some of the states, I think Pennsylvania, some of the experts will come behind me, Pennsylvania's been on the books for over 30 years, I believe. So again, we also have this in our, in 1973, the Maryland Environmental Policy Act enshrines many of these same concepts in the code. But of course, codes are easily amendable and changed, whereas if you have enshrine something in the Constitution, it's something that is elevated in status and puts an added layer of protection for these fundamental rights, so that the Attorney General and our agencies can go ahead and protect those rights of all of the Maryland citizens. Again, I said 7 states have done this and have similar language. Again, this would be construed so that governmental entities and those private actors that are regulated by the government this can be enforced upon them. So with that, members of the committee, I'll ask for a favorable report. I'll stand for questions. We've got a lot of witnesses. And that's it. That's my speech.
Questions for the chairman. Senator Sidnor.
Thank you. Is the bill meant to just to contemplate the natural environment, or are we also talking about the built environment? Because for decades, I know around the state, we've had issues with things like lead paint in our built environment. So I'm curious, what are you talking about, your scope of this?
Natural environment, but the lead would be also, I mean, that's something that our Attorney General's been very active on, lead paint, lots of lawsuits in recent history. But we're talking about the natural environment.
Thank you.
And I mean, obviously, there are lots of environmental justice components to this, which I neglected to kind of rattle off in terms of, the disparities that have been highlighted in a recent NAACP report for especially people of color, and the disparate impact that the environmental impacts have had on people of color.
Senator West.
Thank you, Mr. Chairman. A question for the sponsor: is the Attorney General going to be here today to testify on this bill?
I did not see him signed up, but he did. His office did submit testimony in support.
I know, and I've got some questions with respect to that. So I don't know if I can ask. You're an attorney. Maybe I can ask you questions.
Sure. I didn't draft the testimony,
but let me start. Let me start with looking at the text of the amendment itself. It says the state shall serve as the trustee of the state's natural resources. Now, Pennsylvania is one of the states that has a similar constitutional provision. It says in Pennsylvania, as trustee, the constitutional amendment says, people have right to clean air, pure water, and the preservation of the natural, scenic, historic, and aesthetic values of the environment, et cetera. As trustee of these resources, the Commonwealth shall conserve and maintain them. So Pennsylvania also refers to the state as the trustee. In Pennsylvania, there was a decision 6 years ago, in 2016, which held that when the state decided to permit fracking on some of its lands, the revenues that the state obtained from leasing the land for fracking's purposes could not be put into the general state budget, but rather the state would have to direct them into environmental work. So in Pennsylvania, the Supreme Court of the state, using similar language to this, released a decision which instructed the state how money should be spent. Do you believe that if this is passed, this provision is passed in Maryland, that litigation could result in courts directing the state of Maryland how to spend money?
Well, I couldn't opine on that because I don't know. I don't sit on the courts, but if it's, I suspect that that's under the realm of possibility. But I will also note that it didn't prevent fracking in the first place.
No. Okay.
But the answer is I couldn't opine on that. I have no idea.
Well, along the same lines, I'm looking at the statement of the Attorney General, and what he says is, this is going to be added to Article 48 of the Declaration of Rights.
That's right.
So the Attorney General states, the rights and obligations arising under Article 48 would govern state action, laws, regulations, actions, policies, and decisions by the state of Maryland and its instrumentalities, not private action, in parens, activities of companies, individuals, and other third parties who are not affiliated with the state, close parens. But then he goes on and states, however, by governing state action, Article 48 would affect private parties whose actions are governed by the state. Do you have any idea what that means?
So it's funny, I asked that of, we had a conversation with council on that, and that would, if you're, let's say the government is contracting with an entity, so if you're doing a building or drilling, that type of relationship, so a contractual relationship that the government enters into a private entity. That's what the conversation that we had.
This colloquy is quite important.
Yeah.
Because the language of the amendment is very vague in most respects, and inevitably there's going to be litigation. And in interpreting the constitutional amendment, the courts are going to take a look at legislative intent, and this particular colloquy will be referred to by the courts in interpreting the statute, in interpreting the constitutional amendment, which is why I want to pursue this a little bit.
No, I agree, and so I'll take this opportunity then, because I thought that the testimony, the written testimony that you have in your packet from the Maryland Campaign for Environmental Human Rights touched on this, and I thought they did a pretty good job, and so I'll just read this. The broad language in the Constitution's Declaration of Rights and the Bill of Rights is characteristic of all state and federal constitutions. The purpose of the Declaration of Rights, or Bill of Rights, is to identify those rights that the people reserve unto themselves as being protected from government infringement. The terms of the amendment are no less clear than the language in other rights provisions, and the examples are a right to a speedy trial, excessive bail shall not be required. People have the right to freely assemble. All of those on their face are quite broad, but have received definition through further legislation and through judicial interpretation. So I had some of the same concerns, and so I think that's pretty instructive. I direct you to the rest of their testimony as well.
Well, the reason why I'm pursuing this a little bit is because we have a lot of opposition in this bill folder from business organizations who are terribly concerned that this is going to open the doors to a floodgate of litigation by private citizens suing, whether it's the Maryland Chamber of Commerce and its members or the Delmarva Chicken Association, et cetera, et cetera, et cetera. So I'm looking specifically at the Attorney General's advice and your response, which it seems to me have indicated quite clearly that this article only governs state action, or, as you added to that, contracts that the state enters into with private citizens or private organizations, and therefore sort of are halfway state action. Is that correct?
That's 100% correct, and that's why at the top of my testimony, I spoke to the fact that this is not a novel concept and that other states have had this type of test. But of course, since this is new in Maryland, if this goes into effect, that it will have to be established through some sort of litigation. There'll have to be a test case. Then you'll have that precedent here in Maryland, as we don't have it yet. But that's certainly the legislative intent.
That's why our colloquy is very important
exactly
right now. Because, again, when the courts are looking at ambiguously worded provisions, they typically look to legislative history to figure what those provisions mean. Let me finally double back on my original concern, which is that in Pennsylvania, the Supreme Court of Pennsylvania indicated that this amendment would affect the state budget and could give the state courts, up to the state's highest court, the ability to control elements of the state budget in the guise of interpreting this constitutional provision. And do you believe that that would be the case in Maryland, too?
Again, I don't want to opine. I will defer to folks that actually litigate in this area, but I would refrain from opining at this point. But I would certainly ask you to direct the question to someone that has more familiarity with the Pennsylvania cases.
Okay, great. Thank you.
Senator Huff.
Yeah, thank you. I know they're here today, but I first heard about this bill at my Farm Bureau meeting. They were very concerned about it. And the concern is that the bill, and that's what the opposition testimony is, it creates a right of, once you create a vested right, you have a right to go sue on behalf of that. And I was just interested in your response that because they get these permits from the state, dealing with new buildings or composting, commercial fishing, aquaculture permits, deer management permits, their concerns is that whenever they're getting these permits, there's a new right of action against them, and that there's going to be a new lawsuits against them.
So I think that's the important point. That goes back to the private right of action issue, and that's why I think the conversation with Senator West was important, because it is certainly not the intent. This has not been construed in these 7 other states to create a private right of action, and so I would hope that would assuage those fears, because I just don't foresee that happening.
Okay, thanks.
Senator Castle, you're looking particularly pensive right now.
You know what's coming. Senator Castle, go ahead.
Thank you, Mr. Chairman, Vice Chair, Mr. Chairman. No, this is interesting. I really listening to the concepts, and I'm just trying to understand as I look at the outline here. I mean, on the one hand, you could say, oh, this would just apply to lands the state already owns, but of course we don't need a constitutional amendment for that, because we already have the right to do everything we want with state parks, state forests, median strips of the highways, the rivers, the streams. So obviously this isn't geared towards that. It's geared towards things that the state currently does not already have the ability to influence. Otherwise, why introduce this amendment, right? I mean, we're not just trying to go after stuff we can already do, right?
No, so that's another conversation we've had. So that's why, again, at the beginning of the presentation, I talked about how if you enshrine something within the Constitution, it gives added protection that if something's in a statute, it's more malleable, more susceptible to change, degradation. So this elevates the status of those rights, enshrining them in the Constitution, calling for us to go through a lengthy process of another amendment if we want to change something.
But we have, I mean, I think without exception, we've got like about a 200-year history now of increasingly protecting our state-owned lands. You look what we're doing now with parks, so it doesn't seem like if our intent was, hey, we may have to change the law here or there, that we're really on bad terms. We've got to the extent we want to increase it, we could increase the budget to add more improvements to state-owned lands, and this body has, well, not this body, but the body very large, the ability to do that, which gets back to Senator West's questions about, kind of where are we going with this. But what it appears to me, just because, hey, we got the stuff we can already do, which why put that in a constitutional amendment, and the stuff we can't already do. So currently, land, it doesn't look like you're trying to take over private property per se, but the air, I don't have a deed to the air that flows over my property. I don't have a deed to the water that flows over my property. I don't have a deed to, the wildlife that run across my property, et cetera. So if the state's going to own those, which this is how I look at this, if the state owns those, then doesn't it pretty much render the whole concept of free property ownership sort of a veil? It's ephemeral. It's not really there, because if this is my property, but everything that's moving across the surface of my property is now state property, it's now under the Constitution, and so now the state has just basically, like a heavy fog, just drifted across my property and now controls that, and that's my fear. Is that where we're going with this? Because it looks like that's what this does. Otherwise, why introduce the bill at all? If it doesn't do that, then why have this?
Well, again, I think it just goes to enshrining the Constitution, making it more of a vested right. But I'd never considered that line of argument with some, wildlife moving across your yard. I don't think that is not the intent. That's not the construction of this. So I would just, I don't know how to respond.
Well, then maybe
to that.
we can talk later more. But honestly, I'm just not grasping this, because if it's not intended to expand the state scope of influence and ability to influence private property rights, they don't know why we need this, because we wouldn't want to lock in, we wouldn't want to lock, as Senator West brings to Pennsylvania, so this year we put a whole bunch of money into parks and the environment, but then next year we have a terrible economic disaster or economic disaster or whatever, and we feel the need to take that money as a legislature and move it towards other things. But the courts own it now, and the court says no, because in the Constitution you have to keep that money invested in the ecology. You can't move it. Why would we not want to retain, we and our future fellow? It seems like we would want to retain year to year the ability to reorganize the state's priorities and how we're going to budget, because we can't, I mean, here we are today, and here's how we feel, but I can't tell you what people are going to be feeling in 10, 20, 50 years, but we want to lock them into our priorities today, yet that's what the courts, and we know the courts do that stuff.
No, so, I mean, just like every other element of the articles of our declaration it's a statement that we don't want to recede easily. And so we want to have, these are elevated rights that we hold so sacred, and it's so important that we enshrine them in our Constitution, our Declaration of Rights.
This one's very different. With all due respect, this is very different than saying I have a right to a trial, I have a right to a speedy trial, I have a right to an attorney. I have, those rights are very different than what's here. Those rights do not, what we saw was when we got with the whole right to counsel bill, and how even, it took us so much money to just, once the court said, hey, you do have a right to counsel, and we were scrambling to come up with money for that. It was still pretty limited. I mean, it's just getting attorneys to people in bail reviews. It's not that many people. I mean, there's a lot, but not that many people being arrested. But then you say, let's magnify that. You don't just have a right to an attorney at a bail hearing. Now you have a right to breathe clean air. You have a right to clean water. You have a right to. It just seems. I mean, we've made that. It was Cleveland, I think, was the decision. We've made that look like, penny ante stuff. All of a sudden, we're facing the courts basically directing our budgetary priorities. It just seems like that would be devastating if we're able to do that. There's not many where we run into that. Even like in education, where the courts can come in and say, you're not providing a fair education. The more we do this, the more we surrender the legislative control of the budget. I fear for that. I mean, at some point, we've got to allow our successors to have an ability to set their priorities and not lock those priorities in based upon how we feel today. So, all right.
That's the question of the bill.
Work with you on it. Thank you.
That's the question of the bill.
Senator West, and then we'll get to the panel.
I'm sorry, but this colloquy is really important. This is going to be referred to by Maryland courts for many decades into the future if this becomes part of the state constitution. So I'm sorry to take more time, but I think it's important to do it. Let me give you two hypothetical situations. First, the governor finally gets the extra lanes for the Washington, D.C. Beltway underway. This amendment has passed.
Not if I'm still in the Senate, but.
This amendment has passed in the meantime. Would this amendment give grounds for a group who are opposed to more lanes on the D.C. Beltway to go to court and to take up to the Maryland Court of Appeals the question about whether those lanes comply with this amendment, because they will affect in various ways the air, the land, the water, the wildlife, and the ecosystems of the state, thereby turning the decision over whether to expand the D.C. Beltway over to the Maryland Court of Appeals rather than over to the people's elected representatives.
Well, then that goes back to the private right of action again, and so.
But this is state action.
Well, I understand that, but then that's the state, that's under the purview of whichever agency or government official that's responsible for enforcing those regulations that control that regulate that activity. So private groups excluded, this is a government exercise of regulation and oversight. So
I get that,
yeah.
but if the court, if a group were to bring such a case,
a claim or a complaint to an agency,
maybe a declaratory judgment case that I can't think of what the theory of the case would be, but a case to oppose and eliminate a plan to expand lanes on the D.C. Beltway.
Yeah.
Okay.
Yeah.
And the state were to come into court and argue to the Maryland, what then will probably be called the Maryland Supreme Court, that this particular Article 48 should not be used in this situation, would the Maryland Supreme Court be capable under Article 48 as passed to say, yes, we do have the right under Article 48 to make this decision. We're taking this decision out of the hands of MDOT and the governor and the General Assembly of Maryland, and we're going to decide that because of the extra pollution, et cetera, which would result from these extra lanes, the legislation or the decision to build those lanes is unconstitutional and therefore must be reversed.
So the entity, the governmental entity, would have to be the one exercising that. and would have to be the one bringing that case. So
They would not be permitted for a group of
Private-
citizens, the Chesapeake Bay Foundation, the
not
Sierra
under
Club,
Article 48 doesn't give that private right of direct action. So
because they'd be suing the state of Maryland,
well,
wouldn't
they could do that I mean, that's
Yeah, but this would be an extra grounds for their lawsuit.
not to be construed that way.
Okay, it would not be construed that way. Great. Let me try the second one. The Chesapeake Bay Foundation does an elaborate study of the Chesapeake Bay. And the conclusion of the study is that in order to return the bay to its original pristine condition, it would cost $20 billion a year for the next 20 years. And if that money were spent, the Chesapeake Bay would once again be pristine. That kind of money would require a huge tax increase on the people of Maryland. The governor wouldn't put it in the budget, and some group would file suit against the state of Maryland for failing to do what is necessary to keep the state's land and water and wildlife safe and healthy. Would the Maryland Court of Appeals have the ability to direct the state of Maryland to spend $20 billion a year for the next 20 years to return the bay to its pristine condition?
Now I see your question. And I'll say this, I'll point to cases in Pennsylvania, and I'm going to punt on this because I'm not as familiar with the case law. But I'd ask the witnesses coming up, I'm sure can do that, can answer that question to your satisfaction. But I do see the question now. Yeah. So I'll punt and say, look, for the folks that have litigated in Pennsylvania, I'll ask them to expound upon what the judicial construction interpretation was in that case.
Okay,
and if there is case law that touches on what your question is.
Okay, I was hoping, as the sponsor of the bill, you might be able to come up with an answer which would help to guide the Court of Appeals down the road when situations like this arise.
Of your 15 questions, I think I've answered 13. So.
All right, thank you.
There you go.
All right, seeing no other questions for the sponsor, we'll move on to the panel. Whomever would like to go first.
All right.
Thank you, Mr. Chairman.
Good morning, members of the committee. Can you all hear me okay? Can't tell if this is working. My name is Matt Littleton. I am an attorney in private practice, and I am a member of the Advisory Council for the Maryland Campaign for Environmental Human Rights, whom the chair referred to, and would be happy to, answer some of the many questions that have come up during the colloquy just now. And I think I've got some prepared remarks, but I really want to, use the time as best I can by trying to address some of those issues right off the bat. So the first thing to make clear is the amendment has two distinct parts. The first part of the amendment enshrines a fundamental and inalienable right to a healthy environment, which is already per the Maryland Environmental Policy Act. 50 years ago, that right has existed on the books as a statutory matter, but it's been a right without a remedy. And so what the first part of the amendment would do is provide a self-executing cause of action for private parties, not against other private parties. And this is, as the chair mentioned, no part of this amendment would allow private on private lawsuits, period. That's not the intent. The Declaration of Rights, all of those provisions, without expressly saying so, have been construed as only operating against governmental entities and not against private parties. And so the reference as the chair stated, the reference to effects on private parties that was mentioned in the Attorney General's advisory opinion or opinion on the bill is the fact that understandably, every governmental action has some effect on private parties. And so only indirectly through litigation. May I continue? Okay, thanks. Only indirectly through litigation against the state would private parties be affected. Private parties would not be subject to lawsuits on the basis of violating the fundamental right in the first part of the amendment. The second part of the amendment, which was referred to at the end of the last colloquy, deals with the public trust doctrine. So Maryland common law recognizes a limited public trust doctrine as it exists right now to navigable waters, submerged lands, et cetera. And so what this does is it codifies that public trust and makes clear that it's not limited to navigable waters. It also extends to other public natural resources. It does not take any private property. But to the extent that the state already is exercising through natural resources management some level of control, it memorializes that as a public trust, which is not traditional sort of ownership that you think of in the, run-of-the-mill like private property is owned. It's a very, it's a common law doctrine. Other states have it. Other states have expanded it much more broadly than the Maryland Court of Appeals has. But the point, to get to the question about how does this public trust piece play out, the wildlife reference, for example, that was referred to, if a private suit is going to be brought under that first prong of the amendment, that's unrelated to wildlife, right? That is just a personal individual right to a healthful environment. And so there is no cause of action created by that public trust piece, either private or public. And so it's important, I think, to distinguish between the two halves of the amendment when we're answering some of these questions. To get to the budgetary point, I think as the fact of the matter is, right now, already for, since the inception of this state, there has been a common law public trust doctrine in Maryland, and it has not been used for the purposes that were discussed, the sort of parade of horribles discussed earlier about the public trust being used to basically direct the state's budgetary decisions. If the Beltway is going to be expanded, it's going to necessarily run under navigable waters, and if there's already the possibility, right, that if this public trust amendment had the effect that was being suggested, it would already have that effect. And the fact of the matter is, we haven't seen that in the Maryland Court of Appeals. Courts haven't interpreted it that way. And so I want to be clear that that budgetary concern, there's no reason to think, based on Maryland case law, that would happen here. Finally, I would just say, in terms of the budgeting, sort of overall budgetary restrictions, independent limitations on Maryland causes of action would prevent a private citizen from using the first half of the amendment to come in and say, I'm going to use Article 48, here is my cause of action, to say that I think the Maryland budget should be spent in X, Y way. There are longstanding limitations on, you have to challenge a final agency action. The state budget isn't considered that way. And so it would be impossible now and also under this amendment to make those kind of direct claims. What this would do is, as noted, provide an additional cause of action in circumstances where individuals already have causes of action, whether it be under federal law, the National Environmental Policy Act, the Maryland Environmental Policy Act, other State Administrative Procedure Act, those sorts of claims. This would be an additional claim. It would provide a backstop in the event that the other claims were unable to succeed based on procedural technicalities and so forth. But it would be a backstop only to be employed in a circumstance where government action had the unintended effect of basically inhibiting someone's from having a healthful environment, and which, again, this state has said for 50 years is a clear declaration of policy against that. And so I want to make clear, there's an important role for the amendment, but it should not be construed to be sort of, broader than its plain language, and that the court's interpretation of other amendments would suggest. And I apologize I've taken so much time, but welcome the opportunity to answer further questions.
I'll let you go on because you were being directly responsive to some of the questions earlier, so I appreciate that. Senator Bailey, let's hold off until the end of the panel. So thank you very much, and we'll move on to the next panelist, and then we'll go for questions.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. For the record, my name is Suhani Chatalian. I'm here on behalf of the Maryland Campaign for Environmental Human Rights. The Environmental Human Rights Amendment has been named a priority amongst the environmental advocacy community this year. I would like to raise to this committee this bill's wide support. You will find in the Maryland Campaign for Environmental Human Rights written testimony that the Environmental Human Rights Amendment has the broad support of over 150 organizations and over 2,500 individuals. These organizations range from environmental groups, health professionals, academia, the faith community, student leaders, and more. There's a cultural recognition that as people, a fundamental right to a healthy environment is needed to have a healthy society, to mitigate environmental harms and address environmental justice and inequities that frontline and fence-line communities face here in Maryland. An Environmental Human Rights Amendment is a sound mechanism to ensure that Marylanders now and our future generations can live safely in the environment provided. You'll hear from other panelists who we are so grateful here today, on this rainy day, on what kind of environmental inequities and situations this amendment can be used for. A timely article came out in this morning's Washington Post, which stated that redlining is causing 45 million Americans to breathe dirtier air today. Unfortunately, the placement of people and polluting entities are based often on discriminatory law that has been embedded in our state's policies for decades. I recently worked on a case with a small community in Brandywine, Maryland, where a 6th gas station was built within less than a 1-mile radius of a residential neighborhood. In fact, the gas station that was proposed was within 500 feet of a children's playground. While there were clear environmental and health impacts on the children, there were limited legal avenues that we could take. The gas station fell within the zoning ordinance requirements of the county, so it received the stamp of approval. It is for these kinds of cases where a fundamental right is crucial. We have nothing in our laws addressing cumulative impacts in communities who have continuously faced the environmental burdens the state places on them. This amendment can provide a legal avenue for communities where singular environmental laws and policies have not been able to protect them. With that, I thank the committee for your time, and I'm available to answer questions. Thank you, and we urge a favorable report.
Thank you, Mr. Chair. My name is Sonia Jaya. I am a professor of environmental law at the University of Baltimore with expertise in climate adaptation, water, and energy policy. I was the lead author for California's 4th climate assessment, and my current research compares how state constitutional environmental rights influence norms and perceptions among civil servants. Thank you for the opportunity to share my testimony with you today in support of this bill. You have my written testimony regarding how this amendment provides the principles and legal infrastructure necessary for Maryland to face mounting climate change impacts in the absence of federal action. I'm glad to answer any questions that you might have, but I would like to draw your attention first to 3 points. First, the United States Supreme Court has signaled in 2 recent cases that it will curtail, if not cripple, the authority of federal agencies to address climate change. States need authority, and just as importantly, they need broad guiding principles in order to act in that vacuum that the litigation will likely create. Second, the majority of federal environmental law works through cooperative federalism, in which the federal government relies on partnerships with state governments like Maryland to establish plans and priorities to limit pollution. A constitutional right to a healthy environment can embolden the state in its approach to these federal partnerships. Third, regarding the climate impacts, extreme weather, and environmental justice, these all require working across sectors and geography. Existing environmental statutes do not envision this kind of coordination, and this amendment could, pave the way forward with this. Finally, I would like to add that broad guiding principles are critical in the life of law. It is not only actions in courts that matter. The 14th Amendment obviously is critical to fundamental rights, but that took over 80 years to evolve into its current meaning. That doesn't mean that it wasn't important in the first place to put it in the Constitution. Thank you, and I'm glad to answer any of your questions.
Thank you, Mr. Chairman. So my question is, to start with, when the government uses mismanagement and bad practices and to manage natural resources, such as they did in the 80s 70s and 80s, and we talk about the striped bass fishery, which clearly was by a mismanagement of the Department of Natural Resources that allowed overharvesting by both commercial and recreational, right? And now all the documents are there. It all happened. And then it created such a financial hardship for all the people around the bay, whether you owned a marina or whether you were a waterman, right? They were literally, everybody had to change and do another occupation. How does this Declaration of Rights impact those individuals that were harmed from that? Does that then give them standing?
Thank you, Senator. So I want to again distinguish between the two portions of the amendment. So there's the individual right to the healthy environment, and then there's the public trust piece. I think your question goes more to the public trust piece, and so this amendment would not create a new cause of action against the government, but what it would do is, in the context of existing causes of action for mismanagement of resources, and those are, depending on the specifics, it's kind of hard to, I can't list those in the abstract, but there are existing causes of action for that kind of mismanagement. And so what would happen would be, in the context of that litigation, the plaintiffs could point to the public trust duty as an additional reason why the mismanagement was inappropriate. And how that would play out in terms of whether the bounds of what the state would be responsible for, in almost all cases, I would say, are going to be drawn by statutory law and not this constitutional amendment. But the amendment would provide a backstop in the event that, for whatever reason, the statute did not provide limitations on didn't provide constraints on the government's management of those resources. And I apologize, it's hard to answer that in the abstract, but I would say it would serve as a backstop in that respect, but would not provide a new cause of action.
So, okay, thank you, and I just follow that up with, so let's talk about the individual rights. So I'm not sure that many people are familiar, but a lot of my constituents who live on the water, if they have a creek or a inlet that goes into their property, that property is, if the mouth of that creek is under 300 yards across, right, then that every bit of water that comes back into their property in that creek, the bottom is theirs, right? It's under riparian rights, and they pay taxes on it, right? And so for years, up until 2009, they paid and treated that bottom as it was there, and they still pay taxes today, but they were able to raise oysters on it, right? Because it was their leased bottom, because it was their property. No different than if they were out there farming on their own fields, just like they were. And in 2009, the state said, wait a minute, because it's got navigable waters, we're going to continue you to pay taxes on that, but we're going to say you can't harvest those oysters. Now you can lease the bottom that you own, right, back from the state, even though you pay taxes on it, right, and move forward. And my question is, how would this impact those individuals that are, they've been trying to work this issue, but I know because several of them are my constituents, there's a lot on the Eastern Shore, and then when we deal with this now with the impact of the fact that the tide is rising, this is now impacting so many people that never had this additionally. Now we have farms that all of a sudden, they've got acres of land that were once farmable just 15 years ago that are now underwater all the time. And I was just wondering how this would play out for them.
So with the caveat that I'm not familiar with particular litigation arising out of that 2009 event, I would say, right off the bat, it seems like those individuals would have some kind of a takings claim against the state if their position was, this was our private property under the terms of state law, you've basically taken that away. So this amendment wouldn't speak to that question as to the private property ownership question. However, in what you referred to at the end of your of your comments about the fact that, you know, with rising sea levels and so forth, there's going to be increasing encroachment on the property itself, and not just increasing encroachment of the water, potentially increasing encroachment of polluted water. And so that would be a circumstance in which I would think, again, under existing law, there probably is a statutory cause of action for that kind of damage because it's property damage. This amendment is not limited to individuals that own private property, and that's, I think, part of its virtue is that it sort of extends to everybody. But for those that for those in the situation you're talking about, the amendment would provide an additional cause of action against the state to say, you know, at a bare minimum, you were taking action in a way that is basically preventing me from having a healthful environment on my property where I sit. Whether or not you think you own it or I own it, the point is it's affecting my environment, and so it would provide a backstop in that situation as well.
Thank you.
Thank you, Mr. Chair. So these questions are for both of the two lawyers up there at the dais, the professor and the practicing lawyer. And I'm really going to come back to the same sort of thing I was talking to the committee chair about. First of all, I think I heard one of the two of you say that the first part of the first half of Article 48 does not give rise to any sort of a cause of action from anyone, by anybody at all. Is that correct?
No, I think that was me, and I want to make clear, it gives rise to a cause of action for a private party against the state. It does not give rise to any cause of action against a private party.
Okay. It's very general language. And then the second part is a little more specific than the first part. It says the state shall serve as the trustee of the state's natural resources. And it says, and the state shall conserve, protect, and enhance the state's natural resources. So let me start with my hypothetical about the Washington Beltway. Let's assume, for argument's sake, the Hogan administration finally makes its way through all the underbrush and comes out into the clear, and they have a clear right to construct additional lanes on the Washington Beltway. Would it be possible for some private group, whether the Sierra Club or someone else, to bring a lawsuit against the state and take it up to the Maryland Court of Appeals, arguing that in constructing those extra lanes, the state would be violating Article 48?
So what I want to say again here, we're talking about the public trust portion. We're not talking about the individual right portion. That's what you're.
I guess.
I mean, it seems like that was the.
I'll go with you on that.
Okay. So with respect to the public trust portion,
yes,
that does not create any cause of action, period. And that's where I want to, make clear. The first part of the amendment, the individual right, creates a cause of action for private parties against the state. The second part of the amendment does not create a cause of action where none previously existed.
Well, in Pennsylvania, where the language of the amendment is very similar, it says, as trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. That language was the basis of the lawsuit filed by the Pennsylvania Environmental Defense Foundation against the state of Pennsylvania. So you're claiming that in Pennsylvania, that similar language would sustain a complaint filed by a private group, but in Maryland, the language would not?
So are you referring to the Robinson Township case?
No, I'm referring to the Pennsylvania Environmental Defense Foundation versus Commonwealth of Pennsylvania case, 2017.
And so in that case, if I'm remembering correctly, the amendment served as the basis for the relief, but it did not provide a cause of action where none otherwise existed. So there was existing statutory law, I believe, in Pennsylvania, as there is in this state, that provided a cause of action.
The entire opinion that I've read seems to rely on the Constitution, Article 1, Section 27.
As providing an independent cause of action?
Well, it's the basis of the complaint. You're saying there was you have to have a separate cause of action?
So without the opinion in front of me, I apologize. I'm not going to be able to say for sure, but what I would say is, based on my understanding of Maryland law, that just as there is no freestanding cause of action created by the existing public trust doctrine of Maryland, which extends, as I said, to navigable waters and submerged lands. You can't come into court and just say, by virtue of the public trust, I can show up in court. This would not change that. It would simply change the scope of the resources that are considered to be part of the public trust within Maryland to bring it in line with those of, many other states, the majority of other states, which don't so limit it to submerged lands.
So you're saying that, and do you both agree on this?
I'm sorry.
I'm sorry, Professor, do you agree that the section of Article 48, which states the state shall serve as the trustee of the state's natural resources, et cetera, would not give rise to a complaint against the state stating that the state had violated its fiduciary duties as trustee in a particular situation, that there would be no such cause of action permitted if this is passed?
Sure, so what I can tell you, not being an expert in Maryland courts, but based on surveys of other states that have similar language, it has generally been very difficult for plaintiffs to actually take cases to court, or potential plaintiffs to take cases to court. When these kind of constitutional amendments are interpreted by courts, at least initially, they tend not to recognize the substantive rights and turn it into a sort of minor procedural right. Now, over time, whether or not that evolves into something else is a matter for future generations of Marylanders, both citizens and the state, to work out.
And I would also add, Senator, in terms of looking at the distinctions between the language proposed here in this bill and what's actually in the Pennsylvania Constitution, you'll note that there's the specific section, proposed section B, 48B, I'm forgetting now if I'm getting the letters right, but the language about the state shall not be infringed, that this fundamental right shall not be infringed, applies only to the individual right in the first part of the amendment. It does not apply to the public trust piece. And a court interpreting whether the public trust piece gave rise to a cause of action would look at that and note the absence of similar language under that provision of the amendment as indicative of the fact that the public trust piece is not meant to create a new self-executing right cause of action against the state.
All right, well, as you've been answering my question, I've flipped through this decision, the 2017 decision, and it says, appellant, the foundation, brought a claim in the Commonwealth Court under the fiduciary provisions of the Declaratory Judgment Act against the Commonwealth of Pennsylvania, and the nub of the complaint was based on this constitutional provision. So they used the Declaratory Judgment Act to get into court. Don't we have a Declaratory Judgment Act in Maryland which people could use to get into court?
I don't know that the fiduciary, if there's a fiduciary component to the Maryland Declaratory Judgment Act, I'm not aware of any case in which someone has tried to use the existing common law public trust doctrine as a mechanism to argue that the state is in violation of its public trust doctrine and use the Maryland Declaratory Judgment Act in that way. So I think that would be a novel, it would certainly be novel. And as I said, I think the difference in language between the two amendments would be critical here in the way that the Maryland Court of Appeals interpreted those.
Well, then, if you're correct that this Article 48 will not give rise to any claims against the state which could be pursued in the courts, what's the purpose of it, other than airy persiflage?
Again, we're talking just about the public trust provision here. So if you're talking about what is the purpose of the public trust provision, it is not to create a new cause of action. It is to make clear and codify that the public trust in Maryland extends not only to those public natural resources that have been recognized at common law, but to other public natural resources, not including private property.
All right, you're saying the second half of this does not give rise to a cause of action.
Correct.
But the first half does.
The first half does.
All right, so let's go back to my case, hypo, about the Washington Beltway. Wouldn't it be possible for the Sierra Club to file a lawsuit against the state of Maryland for proposing to build extra lanes on the Beltway, arguing that it would violate Article 48 in that it would hurt the healthful and sustainable environment, especially of Montgomery County, because of all the extra exhaust fumes to be produced by all those extra lanes on the Beltway?
So two responses. First of all, the Sierra Club is already going to have causes of action in that sort of circumstance and probably would
Okay.
litigate.
I give you that, but I
So,
wonder whether this.
Right, the point was just to say, I don't think, this is not going to give rise to lawsuits where none otherwise would exist. But in the context of an existing lawsuit, what this amendment would do is provide an additional cause of action in that circumstance. In order to succeed on that claim, the claimant would have to show an individual right. So this is not sort of Montgomery County as a whole, right? This is an individual right. The claimant would have to comply with the normal principles of standing to show injury, causation, redressability. That's going to be very challenging for a claimant that is not already going to have a viable cause of action under the existing law of Maryland. So, can I imagine, are there circumstances in which this cause of action would extend further than the existing causes of action? I would say yes. I mean, I think you have to answer yes, because otherwise, what's the point of the amendment? But those circumstances are going to be limited to ones in which going back to the preamble of the amendment, right? This is grounded in a conception of human dignity, fundamental and inalienable rights. It's going to be very difficult for somebody to use this sort of amendment to come in and say, well, I don't like this expansion of the Beltway because, down the line, it might cause, incidentally more pollution in the general vicinity, right? It's going to have to be based on the existing case law of Maryland regarding standing, which this amendment does not purport to upend at all.
All right, but assuming you got the case in the Maryland Court of Appeals, is it not correct that the Maryland Court of Appeals in that situation could do exactly what the Supreme Court of Pennsylvania did in 2017 and basically substitute its judgment for the judgment of the governor and the General Assembly of Maryland as to whether lanes should be added on the Washington Beltway?
Well, the Maryland Court of Appeals would not substitute its judgment in that case. The only question before the court would be, has the state of Maryland or its agencies acted in a fashion that has deprived an individual of a healthful environment?
Right.
Right. I guess my response to that is, if the widening of the lanes actually does deprive individuals of a healthful environment, then that is the policy of Maryland now not to do that. And so it sort of presupposes.
So if this amendment, if this Article 48 should be passed, the Court of Appeals would have the right to make a decision under Article 48, which could be inconsistent with the decision made by the people's elected representatives, the governor and the General Assembly, correct?
Well, any time that you have a declaration of rights, it is necessarily a limit on government action.
Exactly.
And so in this context, just as, the freedom of speech operates to take particular government actions that infringe on people's fundamental rights and says that goes too far, you can't do that, this amendment would operate in that fashion. I think the question that your opposing senator goes to, how broadly, in fact, is that going to extend? How easy is it going to be? And I would go back to the, trusting in the fundamental principles that have been interpreted over centuries for what kind of disputes are capable of resolution in the courts. They are ones in which there is a concrete case or controversy in which the claimant can show not only that they've been directly injured, that the injury has been caused and that it is by the particular government action and that it's redressable by invalidating that particular action.
That's right. But it's correct, is it not, that in passing Article 48, the people of Maryland who will vote in the referendum on this will be taking power away from the governor and the General Assembly of Maryland and vesting it in the Maryland Court of Appeals to make decisions consistent with the language, their interpretation of the language in Article 48.
So it is correct. I think what you say is correct insofar as this. As an addition to the Declaration of Rights, it is necessarily adding a constraint on action by the political branches. And as with every other right in every other article in the Maryland Declaration of Rights, the contours of that constraint are going to be interpreted by the courts. So it's true insofar as that is the objection, and that would be, I think, the same whether you were talking about anything added to the Maryland Declaration of Rights.
Okay, let me finish up by raising the second hypothetical. The Chesapeake Bay Foundation has done this study, the Chesapeake Bay, and has determined that if the state were to spend $20 billion a year for the next 20 years, it could return the bay to a pristine condition. That would mean huge tax increases on the people of Maryland. The governor and the General Assembly, in their wisdom or lack of wisdom, decide not to put $20 billion for Chesapeake Bay restoration in the next year's budget. Would this language in Article 48 enable a group to take the state to task and put before the Court of Appeals the question of how much money should the state spend on Chesapeake Bay restoration, and therefore allow the Maryland Court of Appeals to decide how much money will be spent and therefore how much the taxes would have to go up?
No, for two reasons.
Good. Tell me what the
First,
two.
the amendment does not compel any affirmative action by the government, and I'm talking here about both parts. No part of this compels affirmative action. So if the Chesapeake Bay Foundation said, we're going to use state and we want you to fund this, no part of the amendment says that, and even if they say, funding this for the enhancement of these natural resources, no part of this compels government action. The second part, as I mentioned in my initial comments, is that the other question would be, could you attack the state budget, right? That as an independent decision and say, that state budget is affirmative action, and we're arguing that that's wrong because we don't think it's consistent with this amendment. And my interpretation of Maryland case law is that it's true at the federal level as well, and I believe pretty much every other state. The state budgeting decisions are vested in the discretion of the state officials. They are not the sort of thing that is susceptible to a private cause of action for something like this to compel the expenditure of state resources in this way. So I would say no for those two reasons.
And Professor, do you agree with that answer?
I do agree. To put it a little bit more bluntly, perhaps, using your freedom of speech comment, courts can say when the government has overstepped in regulating speech. Courts cannot tell the government what the citizen should say. And so in that sense, this isn't giving, this amendment would not give the courts the ability to legislate, just like any
budgetary
constitutional-
issues?
Yes.
Okay, great. Thank you so much.
All right, Senator Huff.
I'm just curious because, this is a positive right versus a negative right. And our Constitution was originally negative rights where it was basically constraining the government. But this is the new thing, and it's actually more of a European thing. We have positive rights. So education, for example, is in our Constitution is a positive right. And my concern is you say, well, this won't make a change. Well, education's been used numerous times to bring lawsuits against the state. For example, Thornton was a lawsuit that was brought under that article of the Constitution. So how is it that education, and it's constantly litigated, and it's constantly been used in lawsuits against the state, how is it that that positive right of education can be used for that, but this would not be able to be used?
So thank you, Senator. I think I'd first question the premise, which is that this is any more of a positive right than, for example, the freedom of speech. So
No, you question that. The freedom of speech is a negative in that it constrains the government. The government cannot constrict. But a positive right is a right that you have a right to health care, you have a right to a clean environment. Those are straight positive rights, rights to the citizen,
I think
versus a constraint on the government.
I respectfully, Senator, I disagree. I think this amendment, if you look at the way that it is structured and the language, the key is shall not be infringed, and as I said before, it is a constraint on government action. It limits the government from taking action that infringes upon it. It does presuppose a right, and in that sense, it's positive. But I think you could say that about any sort of right in the Declaration of Rights that exists right now. The freedom of speech presupposes that there is a right to free speech. And so I don't think that this is like the education example that you gave, because as I said in the colloquy with the Senator just a minute ago, this does not compel government action where government action doesn't otherwise exist, whereas the right to education that you're referring to might compel the government to affirmatively proffer education.
My understanding is because it's in the Constitution, Article 8, it creates this vested right, and that's what's constantly cited in every lawsuit against the state is Article 8. And so my fear is if we pass this article is what's going to be cited in every lawsuit against the state. And I guess my second part question is, if you get into actions by the state, wouldn't this also deal with state permitting?
Would state permitting be eligible, like if there was a state permit that was issued in a manner that infringed on someone's right to a healthful environment? Could
Yes.
this? Yes, it would provide a cause of action in that circumstance.
See, that's very interesting, because that gets back to my question about the farmers' concerns, and they're back there, and that all the plethora of state permits that they get. So that is effectively, yes, you're not suing the farmer, but if you're suing the state under all these permits that they get and that they need, therefore, that would have a negative impact on them. Okay, thank you.
Further questions from the committee? All right, thank you all very much. It's very helpful. Thank you. All right, we'll now move on to the next panel. We'll go with Antonio Dismel, Stephen Claghorn, Caitlin Schmidt. Let's see.
Chairman, members of the committee, my name is Caitlin Schmidt, here on behalf of the Center for Progressive Reform in support of Senate Bill 783. Everyday local and state governments are granting permission to industries to pollute and deforest Maryland's environment. In turn, this is having serious effects on the health of our state and our bodies. Senate Bill 783 acknowledges that existing laws and regulatory frameworks in Maryland do not adequately protect Marylanders. This lack of protection comes in many forms, including inadequate enforcement, permitting compliance of environmental rules, and limited resources for governmental agencies that enforce our environmental and public health laws. A constitutional amendment would serve as a stopgap to this imperfect system, especially in addressing new, emerging, and more generalized threats that are not captured by existing law or implementation of that law. An amendment would provide a way for overburdened and underserved communities in Maryland to push back against further degradation of their communities and demand remediation of existing harms. In 2021, Maryland Department of the Environment's Water and Science Administration took 55% fewer enforcement actions than the 24-year enforcement average. This number has been steadily declining over the last 20 years, and as a result, noncompliance with Maryland's environmental laws, clean water laws in particular, are rampant. Take Maryland's industrial stormwater permit sector, for instance, which covers approximately 1,200 operations across the state, like auto salvage yards, metal recyclers, and landfills. These facilities discharge heavy metals, chemicals, and other compounds into Maryland's waterways. Between 2017 and 2020, roughly 2/3 of inspections of these operations found that permittees were not in compliance with their permit terms. So out of 1,305 permittees that were found in noncompliance, MDE only took actions against 6 of those facilities. This is less than 1% of the facilities found in noncompliance. So this is just one of many examples where this amendment could foster more appropriate resources to ensure that state agencies charged with protecting Maryland's environment, health, and natural resources do so with the fervency needed to achieve their stated missions. For these reasons and many more, we support a favorable report on Senate Bill 783. Thank you so much.
Good afternoon. My name is Antonio Dismel, and I'm a Baltimore City public school student who attends Reginald Flores High School. Baltimore is a big city with a population of around 610,000. It is unfortunate that with all the taxpayers in Baltimore, that a lot of the systems do not work as well as they should to protect the health and well-being of citizens, such as trash pickup, healthcare, water treatment, air pollution, and maintenance. But that should not mean that the government and leaders of such a great city should not provide services for decent human living as people are left to suffer and dwell in it. Every human is granted the right to live when you are first born from the womb. That's a basic human right. This also should coincide with having the right to clean water, air, and the environment that you live in. As our government, your job is to protect, serve, and lead the people. That's the reason you were chosen for the job. By not enacting the Amendment for Human Rights, you'll be failing at the job you were assigned to do, which means that you should and will need to be replaced. Thus far, During my own personal journey, I lived the majority of my life in an area with horrible air quality and not the best water systems as well. I lived on Wilkins Avenue, about 2 miles from the trash incinerator. As years have gone by, I've watched countless family members, peers, and neighbors become diagnosed with breathing issues such as asthma, bronchitis, and long-term lung disease. By enacting this bill, you will be implementing systems that will help shut down polluting facilities so that other families like mine and my neighbors will have good quality of life in a safe and clean environment. I urge you to enact this bill, not just for me, but for the future of the youth. Thank you.
Good afternoon, Mr. Chair and committee members. My name is Stephen Cleghorn. I'm a member of Maryland Catholics for Our Common Home. We're a group of Catholics across Baltimore and D.C. area that are advocating for this passage of SB 783. Over 500 Catholics have signed our petitions, and our Maryland Catholic Conference, which represents our bishops, has also come on board as supporting this amendment. I've been trying to listen to this, but my hearing aids went out. Okay, so if I missed something important, let me know. But here's what I know. The preamble to this bill here, to this amendment, says all living things are dependent on the gifts of a healthful environment. The full expression of human dignity is incompatible with a degraded environment. A sustainable, regenerative ecosystem and stable climate are essential to support a vibrant society and economy. Access to a healthful and sustainable environment is a birthright of every person. That's in the preamble. I think that means that walks before the law. We hold these truths to be self-evident. We start with that. I don't hear that happening here today. What I would like to ask industry representatives, be they from incinerators that make energy out of trash, be they from monoculture agriculture, be they from poultry operations, I would like to ask the industry representatives to say, don't you believe in those same things that are in the preamble? Will you stand up here and tell me that we do not have an inalienable right to a healthful, sustainable environment and climate? When I hear that from the industry, when I hear them being honest about that, then I will be grateful for coming. Let me end with Wendell Berry. Whether we or our politicians know it, nature is party to all our deals and decisions, and she has more votes, a longer memory, and a sterner sense of justice than we do. Thank you.
All right, thank you very much. Questions from the committee? Seeing none, thank you all very much. Thank you. All right, we'll now go on. Is Doug Gansler still here? Carlos Sanchez? John Breen? Linda Gale? Stacy Hartwell?
Chairman Smith, Vice Chairman Wallstreicher, members of the Senate, it's good to see some of you once again. I am here today as a member of the Executive Committee of the Maryland chapter of the Sierra Club, asking for a favorable report on this bill to have this amendment added to the Constitution, or at least have a referendum on it put on the next general election ballot. We've heard a lot of conversation already. I think there's a couple things that I would want to emphasize on behalf of the club. One would be the fact that this is not affecting private-on-private lawsuits, right? This is against state actions. The second thing would be that we are also, sorry, I lost my track of thought there. The second thing would also be that we are specifically referring to issues that have to do with finding standing in courts, right? So you would have to find that there is a real cause that has occurred that has been caused by state action. So for example, I think Senator Cassidy talked about owning land and not having rights to the water that flows over it or the air that flows over it. But if there was a state action that negatively impacted that to the point that he had a health issue because there was unhealthy air over his land, even though he doesn't have the rights, he would then have a right under this amendment to be able to find a cause of action to then have that stopped and possibly corrected by the state. And that's really what we're looking for, is we're looking to give private citizens one other chance to be able to stand up against any governmental oversight that might negatively impact them to the point that they'd be able to prove standing in a court. So this amendment will actually really have a positive impact. And I think the final thing is, we've talked about, well, if it's going to be such a limited scope, why is this even necessary if it exists in common law? And I think it really boils down to the simple fact that if we can say that an action by the state has made people sick, has made them unhealthy, or has had negative impacts to our environment, then that's probably a reason for us to say we shouldn't allow the state to do that. And even if that's such a slim margin, I think that's worthy of making sure that this language is added to the Constitution. We urge a favorable report. Thank you for your time.
Hello, Chairman Smith and fellow committee members. Today, I'm urging you to support Senate Bill 783, the Environmental Human Rights Amendment. My name is Linda Gale, and I'm a sophomore at Annapolis High School. I'm 15 years old, and I don't know where the world will be by the time I'm your age. I can't speak for my entire generation, but from what I see in community, most of us are concerned for our futures because of the climate crisis. That's why the Environmental Human Rights Amendment has to be passed now. It gives hope that this planet will be healthy and livable for future generations. Maryland's youth care a lot about this issue. At my school, groups ranging from anti-racism organizations to Model UN to our school newspaper have been talking about this amendment. Our Environmental Action Club presented to the school about why it's so important, and we've shared the petition with our communities. I've connected with high schools across Anne Arundel County, all of whom want to see this bill become part of our Constitution. So I ask you today to support democracy and put this bill on the ballot so that we, the people, can have our voice on what goes into our Constitution. Allowing this bill to die once more in committee sends the message that our voices aren't being heard and that the youth's voices don't matter. So when you vote for this amendment, I ask you to think of the children in your communities, because we are the ones who will have to live with whether you choose to recognize our environmental human rights. Thank you.
Good afternoon. My name, again, for the record, is Stacy Hartwell. I am the chair of the Environmental and Climate Justice Committee for the NAACP Maryland State Conference. I am also a resident of Prince George's County, one of the most environmentally overburdened and polluted counties in the state. Unfortunately, across the country, race is still the #1 indicator of where toxic polluting facilities are located. Pollution and other environmental hazards are concentrated in communities of color, regardless of economic status. Maryland, unfortunately, is no exception. We cannot continue to undermine these communities and still expect them to thrive. This legislation serves as an equalizer. It empowers organizations with the leverage they need to help make fair and equitable decisions concerning the environment. You know, accountability is a tool of a civilized society. The state is supposed to protect, preserve, and enhance our natural resources, and therefore they are to be held responsible to ensure our well-being as stewards of these natural resources, not for the interest of corporations, shareholders, but for us, we the people. Corporations are not people. The 1960s exposed and elevated the lack of environmental protections and public health dangers to communities of color and those without political influence. And 1/2 century later, we are worse off due to cumulative environmental impacts. And even though the Declaration of Independence declares we have certain inalienable rights, there are too many instances in this state clearly demonstrating our government's failure to ensure those rights. This amendment is an opportunity to restore these protections and clearly demonstrate our Constitution is for the people, by the people, so we will not perish from this earth. Senator Smith, we regard you as a champion for the people and are grateful for your leadership on this important legislation. We encourage a favorable report. Thank you.
I'm Jack Breen. I'm a lawyer in Annapolis. I can't compete with these two people. My focus is a little bit different. I want to focus on the facts that are surrounding this very city. The Inner Harbor, your Naval Academy, and the businesses there. Rising sea levels. It's a one-page statement, and it's got the cover page of a report published by the City of Annapolis and the United States Naval Academy, Climate Resilience Context. There are two graphs that describe the problem of sea level. These documents are available on the web or the internet if the copying, delivering of these documents doesn't help. Let's look at Exhibit 1, prepared by the Naval Academy study. It has 3-4 lines because the different work groups had different data to produce the graph up the chart. So in the first sea level rise for Annapolis, the Naval Academy did this. It starts somewhere between 2030 and 2034. We'll look at 2050. At 2050, year 2050, it projects that the sea level rise just from melting ice flow in the Antarctic and in Greenland, they project to be between 1.9 and 2.0 feet. And as we get to 2100, which is only 78 years away from now, some of us will still be here.
Yes, we will.
There's a rogue figure. It comes up with a number of 8.2 feet. That appears to be, that line was prepared by the FEMA flood evaluation for doing evaluations for flood insurance and flood risk. And that includes not only rising sea level from sea level rise, but also the averaging of flood risk from storms. The medium sea level rise here is about less than 5 feet, between 4.5 and 5 feet. The second graph, if I may complete, shows the remedy proposed by the City of Annapolis and the Naval Academy. It proposes a seawall of 5.2 feet, protecting the Naval Academy and protecting the Inner Harbor and all the businesses going into it. The most important part of this exhibit is an NOAA report entitled the 2022 Sea Level Rise Technical Report. This is prepared by the NOAA, and their offices are here in Maryland, just outside of in Silver Spring. They use an average of all the East Coast cities, and they project that by 2050, the sea level rise on the Northeast states, which includes Maryland, will be between 10 and 12 inches.
Mr. Breen, could you just briefly conclude?
Okay.
Sorry.
Most importantly, they project that if we don't change the release of methane and carbon dioxide into the atmosphere, the sea level rise could reach a total of 3.5 to 7 feet by the year 2100 in this harbor and this bay. And that's going to affect your economy, your businesses, where the Naval Academy can stay here or not remain. This is not a subtle issue about chicken farmers or highways. This is your city. You sit and hear these cases here. You're going to watch this happen. The legislator's going to watch this happen if the state continues to do nothing.
Thank you very much.
Thank you for your time.
Thank you. Thanks for hanging in there with us. All right, questions from the committee? All right, thanks. This is an excellent panel. Thank you all very much. Thank you. We'll now move on to Robin Jessica Clark, Michael Powell, Lindsay Thompson, Holly Porter,
Michael Powell here on behalf of NAOP and the Maryland Builders. We are concerned that this does create a number of causes of action. I think Senator West's points were directly on point. First of all, there was a
Actually, you're right.
reference-
Excuse me. Let's go ahead and go with Ms. Clark first. So she's
Okay.
the last proponent of the bill, and then we'll switch over to the opposition panel.
Thank you, Mr. Chairman, members of the committee. Robin Clark, Chesapeake Bay Foundation, here today in support of SB 783. Chesapeake Bay Foundation points out in our written testimony, and I'd highlight here, that the permitting decisions by state agencies and other agencies are one of the most widespread touch points that our citizens have with environmental issues. And we think that this legislation, if it was to go forward and constitutional amendment was ratified, could provide a new lens for the state agencies as they make their decisions that have an impact on the environment, and really would most likely, although it can't be exactly determined, just add a reasonable consideration for the effect of their actions on the state's natural resources. We think it's unlikely the amendment will have a dramatic effect on litigation, but rather just update the state's actions to account for the value that we now know our natural resources possess. Elevating and enshrining this right as a fundamental one could create consistency across different administrations. That, again, referencing the administrative branch of government. It could create consistencies for budget considerations in good times and in bad times, and just create that base level, that base standard of recognition of the value of our natural resources to the public. For those reasons, we support the legislation. Thank you.
We'll conclude the testimony for the proponents of the bill. Senator West, you have a question for the last proponent?
Yes. Thank you, Mr. Chair, and it's brief. The similar language is in an amendment which was added to the Constitution of the state of Pennsylvania. And are you aware that since 2017, there have been 13 cases that have reached the Supreme Court of Pennsylvania based on the language in this amendment?
I wasn't aware of that number, but I was aware of case law.
Okay, thank you.
Okay, thank you very much. That'll conclude the testimony for the proponents of the bill. Now we'll switch over to the opposition panel. And yes, sir, our apologies.
I'll try again, Mr.
There you go.
Thank you. Michael Powell here on behalf of NAIOP and the Maryland Builders. And we are concerned about the amount of litigation that this would be created. First of all, very quickly, I heard a number of the proponents say that you had to have standing. The first two lines of this amendment says every person. And so every person can bring a suit. And Senator West's comments about the 10 lanes on the highway are exactly apt. But you could also say a crematorium in Baltimore. You could talk about a poultry farm on the Eastern Shore. Whether you sue the owner of the crematorium or the contractor who wants to put the road in, the point is that when you sue the state and stop them from being built, you stop the operation. If I've got a poultry farm on the Eastern Shore and I've just spent $1 million buying the property, and now I've got my permits, or I've got a crematorium and I've gotten a special exception from the zoning authority to say that I can add that to my funeral parlor, and now a party goes in and sues the state or sues the city and say, I can't do it, what are you going to do as a lawyer? You're going to move to intervene as a defendant, whether you were named in the case or not, because now your livelihood is at stake in that. So it clearly will allow for much more litigation. And the idea that this is just an additional cause of action, if it already violated a statute, if you didn't have your permits, if you didn't comply with the laws that this body and Congress passed, you stop it anyway. The point is that this amendment would allow them to bring a cause of action even if you've complied with all the statutes. That's the point of a constitutional amendment. And you keep hearing people talking about a healthful environment. There are two terms in that, healthful and sustainable. There's been a little bit of discussion in this group this year about buildings and climate change. I would suggest to you that anyone who claims that something being done or approved by the state would create more greenhouse gases would affect sustainability and therefore create a cause of action. And with that, I'd be happy to answer any questions.
Thank you, Mr. Chair, members of the committee. My name is Lindsay Thompson, here today in opposition on behalf of the Maryland Grain Producers Association, representing the grain farmers who grow corn and wheat and barley across the state. So I'd first like to say that we are not opposed to a healthful environment or a human environmental rights. We are concerned about the lack of definition and therefore the lack of certainty around what that definition might be when decided by the courts. We think that healthful and sustainable have many different definitions and interpretations to every individual, and therefore are concerned that our ability to continue to farm in the state the way that we do in compliance with all the existing laws could potentially be at stake. Virtually everything that we do as farmers is subject to a permit or certification from the state of Maryland. We have to have nutrient management plans that are audited. We have to have nutrient applicator certifications. We have to have pesticide applicator licenses. All of those are issued and approved by the Maryland Department of Agriculture. And if someone believes that the issuance of those permits, licenses, or applications is violating their right to a healthful environment and in turn sue the state and the Department of Agriculture, could that potentially impact our ability, our right to farm in the state of Maryland moving forward? And so even if we as individual farmers cannot be sued under the statute, we do believe that it would unduly impact our ability to continue to support our families and our family farms. And with that, we would urge an unfavorable report. Thank you.
Thank you, Mr. Chair, members of the committee. Colby Ferguson on behalf of Maryland Farm Bureau. And we come in opposition of this bill. And it's not that we come in opposition of a healthy environment. It's that we come in opposition of a bill that we believe really opens up a Pandora's box for lawsuits. Everybody keeps talking about, well, Pennsylvania did it already. I think it's pretty evident now, based on when Pennsylvania passed it 30 years ago, their court system came in and put it very restrictive on what that could be done. And so the number of cases that came 30 years ago till about 5 years ago was very little, because they basically narrowed the focus on what it could be used for and really didn't really get into what we've heard today on some of the things, and what we've heard in a lot of the written testimony is that would happen under today. 5 years ago, when the court system opened that up or amended their interpretation, from that, you've had 13 lawsuits in the Supreme Court in Pennsylvania, and a lot of those lawsuits have moved into some agricultural side, whether it be for the Susquehanna River or if it be for farmers in Lancaster County. But what we're seeing is that there's no doubt in my mind that that's what will happen in this, because if you look at what a lot of the Maryland proponents of this bill look to do, they look to sue as soon as this is passed to start trying to stop things. So obviously this is being done to try to stop what they believe this legislature, the government administrations are not doing at a satisfactory issue. I personally believe, the way it's written, that farmers could start to sue towns and municipalities due to the wild climate that we're in right now. I believe that Montgomery County is a heat island effect that causes significant weather that has basically hit Howard County and causes significant flooding down through some of the old towns. And so I believe this opens up a Pandora's box of options that I don't think has been done, and we ask for an unfavorable report.
Thank you, Mr. Chairman and member of Judiciary Committee. My name is Far Nasir. I'm actually here for Holly Porter on behalf of DCA. I'm a chicken grower in Pocomoke, Maryland, and also the DCA president for 2022. DCA represents 1,600 members. That includes growers, allied members, and chicken processing companies on Eastern Shore of Maryland. And we oppose SB 783 and ask for unfavorable position. To be clear, our chicken community is not does not oppose a healthful and sustainable environment. Since thousands of chicken growers, the workers, myself, my family, we are all in Maryland ourselves. Chicken growers are already under a number of laws, regulations, and permits, and all that were created with science-based data, and all that offered numerous opportunities for public hearings and for public to participate. Proponents of this bill have written, and I quote, "If Environmental Human Rights Act was in place, residents who live in the same airshed and watershed with the CAFOs and whose land, water, and health were being harmed by these CAFOs could invoke the violation of their rights to a healthful environment." Our concern is, how would that happen? If the growers are following all laws and rules that are in place and doing all that have been asked of them, then how would residents invoke their rights? If not direct litigation on the farmer, then litigation on the county or state governments, which would gain impacts of farmers trying to begin or expand their operation. May I continue? Okay, thank you. Our chicken community is unfortunately familiar with litigation, having had a lawsuit brought against a family farmer just 10 years ago based on mistaken identity of a pilot on the farm. It cost millions of dollars and years of heartache. Chicken farmers do not have grants to pay for the court fees. We urge an unfavorable vote on SB 783. Thank you.
All right, so we have two questions for the panel. One, Senator Watson and Senator West.
The first gentleman that spoke, just a quick question. And so I was sitting back here, and it's really interesting to see, listen to the back and forth. I thought when I first saw this bill, it was more aspirational goal, and I think we all agree with the intent. But what the proponents stated, and I had jotted it down, that they thought that this excluded private property. And a question that I was going to ask, but once they said it excluded private property, I didn't ask it. But you've led me to believe that it could include private property. So my simple example is, I own 200 acres of forestry, trees, and what have you. And I should be, as the owner, I should be able to develop it. Say I want to put, houses up, make a new community. Are you saying that this bill could lead to the potential that I would not be able to get the permit that I want through my state county because of the potential impact of not conserving that forest area?
Exactly. That's why I'm here on behalf of NAIOP and the Maryland Builders, because of that concern. If you go in to get your permits and you're going to take down some trees and you're going to build some houses, it's going to be on the waterfront. I live on Kent Island, okay, and we've had that long fight over 4 seasons for a long time.
Right.
You've got all of your permits, but a person, Bill says every person, okay, but a person comes in and says, this affects the sustainability of my environment, and you are required by the language of this, the state shall conserve and enhance natural resources. And I think cutting down those trees and putting this development on the waterfront would not enhance or conserve. That's exactly what the amendment forbids. And it does not say on public property. It says of the natural resources of the state. The natural resources of the state are as much on private property as on public.
So let me ask another question. I have a different bill that's kind of held up in rules, Senate Bill 931, impact of actions on climate, labor, and environmental justice, right? And that seeks to do an assessment of any new development, new building, whatever, to make sure it doesn't inversely impact overburdened communities and those types of things. It's already been heard in the House. And so under the way you understand this bill, if there is an existing coal-fired plant or smokestacks or something that we know is blowing through the wind in a impoverished community or what have you, and we as a state are trying to switch to clean energy over time. We want to remove that. But with this bill, would that enable, this community as litigants against the state because it's there and the state doesn't have the tools to immediately stop it?
We're assuming that the plan is in compliance with all state laws, right? Because if they're not in compliance with state law, they already have an action against the power plant to stop it.
Well, so say it's in compliance with state law, but research has shown that, inhaling that smoke over a period of time is detrimental.
This would provide an additional cause of action if the person believes that that power plant is affecting health or sustainability. But it's not merely that community downstream.
Right.
Every person can make a claim on sustainability. And because sustainability is a climate change concept, anyone who says that there's CO2 being issued into the atmosphere by the power plant, by the car you drove, by the gas stove you have in your kitchen, any of those create a greenhouse gas and can affect sustainability.
Okay, thank you for that. Appreciate it.
Thank you, Mr. Chair. So, Mr. Powell, you and I have worked together before.
Yes.
You're one of the state's best-known environmental attorneys. I'm concerned not only about the litigation, but I'm worried about the transfer of power from the people's elected representatives, the governor and the members of the General Assembly, to the unelected judges in the Maryland Court of Appeals. Does that concern you?
It does. The language of the second part of this, it says that the state shall conserve and enhance, right? That's an obligation. As you point out, it's the word shall. It's not you will where possible or where the legislature tells you to. That's a constitutional obligation of the state. And I don't know whether the particular example you've got of the Chesapeake Bay Foundation or something similar, it's easy to come up with, where the state says, where an individual says, you, the state, have not acted in a way to conserve the natural resource.
And enhance.
And enhance. And therefore, this court, determine you have failed your constitutional duty and must take this action in order to conserve and enhance. That's really what happened in Pennsylvania, right? Whatever you think of fracking, what the Pennsylvania court said is this money has to go to that purpose because you're a trustee of the land.
Let me refer you to a case that was cited, I can't remember the name of the case, some years ago, in which the Court of Appeals held that the section of the Maryland Constitution that guarantees children a good education, that had been violated because the state had not provided a good education. As I recall, in that case, the Maryland Court of Appeals stepped in and basically determined the policy of the state and ordered more money to be spent on children's education. If this amendment is passed, is it not possible that the Maryland Court of Appeals, using the same sort of an argument, could step in and order the state to spend more money, perhaps much more money, on environmental remediation?
Absolutely. It was as the comment I made by the other senator had suggested, this is a positive obligation. This is not like the First Amendment where it says that you'll not infringe the rights, okay? That there's some language of that in the first part. In the second part, it's an obligation of what the state must do. They must conserve and enhance. The truth is you can't enhance something without spending money on it. And if you haven't spent enough money to conserve and enhance, then you failed your constitutional obligation, and that's what courts do, is they enforce constitutional obligations.
And to finish this line of questioning, in my view, the voters elect their elected representatives and their governor to make decisions on how much money the state is going to spend on various public policy programs, and therefore how high the taxes are going to be. And so the fear I have here is that we're going to turn that responsibility in the environmental area over to the courts, and they will decide how much the state will be spending on environment, not the people's elected representatives. Is that a concern of yours?
Absolutely. And I don't have to tell you this. You do a balancing act, right? How much money do we spend on the Chesapeake Bay, and how much do we spend on helping well, I said here, you talked with a lot of the programs you're trying to run to help people coming out of prison or young mothers coming out of prison to have babies. you have to make those balancing decisions. But what this does is it takes a certain set of rights, sustainability and healthfulness, and elevates it above the others. You've got to put money for that. You don't have to constitutionally put money for these other items.
And to finish, and the courts will be given the right under this amendment to tell you how much you have to spend on those things.
That's what a constitutional amendment does, is it gives the court the ability to enforce the constitutional provision. Yes.
Thank you.
Thank you very much. Thanks. Sure, go ahead. Senator Cassidy has a question.
Thanks for coming in. Yeah, just a quick, what Senator West's example, and I brought it up a little earlier, see what your thoughts are on this. I mean, we as a legislative body, obviously right to counsel is one that is an express right under the Maryland Declaration of Rights. As a legislative body, we weighed that, and there was a push to say, well, let's expand that to have a right to counsel in bail hearings. And then we did the financials on that and said, whoa, that's a killer. Let's we'll throw some money at it. And we threw some money at it, and it was sort of limping along there. But then the Court of Appeals stepped in because it was a budget buster, and we were working towards that. And the Court of Appeals was, or the Maryland Bar was doing volunteer lawyers and panel lawyers and trying to Band-Aid our way through it. But then the Court of Appeals stepped in and said, oh, no, that is an affirmative right. You have a right to a counsel and next thing we knew, we had this incredible bill for legal services to be provided. So I guess that's sort of what you're talking about is in the one hand, we were, as a legislative body, we were able to weigh it and say, well, yeah, we want to give right to counsel. We have education expenses. We got the environment. We got to have transportation, all these things, and taxes are already one of the highest in the nation. So we're going to weigh that a little bit heavy. But under this, if it's a fundamental right, the courts would step in and say, no, you've got to spend that much money, and you either take it out of all these other priorities or you raise taxes because we're taking over here. I mean, that's what we're talking about, right?
That's exactly it, and it's even worse because how much money does it take to enhance the natural resources of the state?
Yeah. A little bit more than it does provide effective assistance to counsel, I would dare say.
Yes, though I will say that if you pass this law, I as a private attorney, environmental attorney, will make a lot of money.
Make a lot of money.
So my resources will be enhanced, but I think it will be a problem for the state.
Yeah. Thank you.
All right, thank you all very much. Thanks for hanging in there with us. All right, so next, Mr. Sanderson, you're up. And do we have Angelica Bailey? Is she here? There you are. Did Lindsay Thompson come? Yeah, that's right. There you go.
Thank you, Mr. Chair and members of the committee. I'm Michael Sanderson with the Maryland Association of Counties. We submitted written testimony, and I think it raises a number of issues that have already come up in the conversation with the committee. I want to try and be respectful of your time. I will just say, I'm in awe of all the conversation you've had with all the different stakeholders and all these different perspectives and the back and forth with committee members and all the stakeholders here. It's part of what makes the legislative process the right way for decisions like this to get sorted out. And I very much share the concern from some committee members that in the interest of pursuing a noble idea that this amendment might represent, you could easily transfer a great deal of the ultimate arbiter of Pennsylvania environmental policy is not their General Assembly anymore. It's the courts. And I don't think there's any way you can say, a lot of folks says, well, I read it this way, I read it that way. At the end of the day, that's ultimately what you'd be putting in the Constitution. They would decide whether this broadens standing. In the 2013 case in Pennsylvania, they seem to suggest that, in an Illinois language, there seems to be a broadening that you don't necessarily need a specific injury to have standing, even if it doesn't change the statutory definition there. Pennsylvania spoke to whether the state has, by not actively taking on its stewardship duties, did they violate this clause in the Pennsylvania Constitution. I think the right place for this kind of policy to be sorted out is with actors like you all who are accountable back to the public and have broad stakeholder participation, not just those who can file complicated legal briefs before the Court of Appeals. It's the right place to sort this stuff out. So we've raised a number of other issues in our testimony. I want to be respectful of your time, but I think take away this robust conversation as what could be lost in the shuffle of moving to making this a constitutional right. That's far more specific than education, by the way. I know I'm out of time, but as you speak to whether this might evolve into lawsuits over the specific performance of the state to live up to its constitution, this is way more rigid than the entitlement to a thorough and free system of public education. It's like 10 words in the Constitution, and Thornton was all born of that.
Good afternoon, Angelica Bailey. I am the Director of Government Relations for the Maryland Municipal League. I will be very quick, I promise. You'll never hear MML say that we are not in favor of environmental protection. Climate change mitigation is one of our strategic initiatives this year. It was last year as well. But we're talking about creating a new fundamental right, and that's a big deal. Only 6 or 7 states already have this. Maybe we just don't have enough data on the aftermath of enacting something like this. And this isn't just a harmless experiment. I completely agree with Mr. Ferguson that this could open the door to a floodgate of litigation. Even if it's not a floodgate, a trickle wouldn't be helpful to local governments. We're still dealing with the challenges and the financial implications of the last 2 years. We really can't afford additional litigation right now. And we already have federal, state, and local laws that speak to these issues. So we really just don't see a need. We appreciate the sponsor's intent, but this bill is not only redundant, but could be counterproductive. Thank you.
All right, seeing no questions from the committee, thank you both very much. And with that, that will conclude the hearing for Senate Bill 783. We'll now move on to our last bill of the day, Senator Heddleman with Senate Bill 704. And Senator Lee, I'd ask you to take the chair, please.
I bring up my panel, please?
Yes.
Good afternoon, Madam Chair, members of the committee. Senate Bill 704 is an important bill that really continues a practice that we put in place last year. Last year, as you may recall, we had federal money that we directed towards using the judiciary to cover the costs of pretrial home monitoring. Those charged with but not convicted of a crime should not bear the financial burden of their monitoring. This puts low-income defendants in an impossible situation. They are presumed innocent, and they often have lengthy delays in awaiting trial, and home detention can likely mean that they are potentially unable, without home detention, unable to earn a wage. Requiring them to pay for monitoring puts them in debt and forces them often to choose between paying for basic essentials such as rent and childcare, and it can be quite costly. We believe that people who are presumed innocent shouldn't be criminalized for having an inability to pay. And we directed federal funds last year to pay for this home monitoring. These are people who qualify if they are unable to pay for counsel and they qualify for representation through the Office of the Public Defender. They will also qualify for home monitoring. This program has been working. The bill's effective date was in July, but it actually didn't kick in until October, I believe. And it's been working. As you will see, if you click on your committee testimony button, everybody supports this bill with the exception of the judiciary. And I want to talk a little bit about that. And I did have a conversation with Judge Morrissey about this issue recently. They were not happy that we directed them to manage this program. They don't see it as a judicial function. They see it as an executive branch function. Having said all that, they've been doing a stellar job. They have it's been working. And we do not want to forego the possibility of these federal funds continuing. The bill that we passed last year sunsets this summer, so we want to continue this program. Now, the bill as it's currently structured doesn't specify that it is targeted to those federal funds. I'm certainly open to having that. I think we're all open to having that conversation. I want to point out something else. There was a work group mandated by that legislation last year. That never happened. Part of the point of the work group was to figure out a long-term solution to this issue. And so that is included in the bill again this year to ensure that we can have that conversation and we can figure out what entity is the most effective and the best one to address the issues of pretrial home monitoring and who pays for that. So I feel like this bill is a short-term measure, but it puts in place the mechanism to be able to consider what the long-term policy solutions are on this issue. So I'm going to let others on this panel talk about some of the details. They can provide you the information about how it's working on the ground and how it's working well. And you'll be able to talk at another panel to some of the folks who are the companies that are being compensated for this pretrial home monitoring. So with that, I would urge a favorable consideration of the bill, and I will end there. Thank you.
Good evening. My name is Todd Oppenheim. I'm a supervising attorney in the Public Defender's Office. My office asks that the committee support Senate Bill 704. No one awaiting trial presumed innocent should be incarcerated as a result of their financial circumstances. However, prior to October of 2021, if you couldn't afford pretrial home detention fees, you generally couldn't get it, even if a judge allowed it. Once on home detention, if you missed payments, you could be rearrested. If Senate Bill 704 is not passed, these injustices would reemerge. Senate Bill 704 merely seeks to continue the General Assembly's successful efforts from last year in passing legislation out of this committee in regards to pretrial home detention inequity. Because of the 2021 law, money became available in October for pretrial home detention fees for poor defendants. From my perspective as an attorney of 18 years representing adults in all phases of the system, this has been one of the most impactful actions for our clients. Now, you're going to hear all kinds of proponents, even the home detention companies are allied in this push to continue the funding here. I've seen it firsthand, $6,000 over the span of a year plus pretrial process, only to have a client's, only to have the funding bill take effect and pay for the client's fees, and then a couple weeks later the case is dismissed, and this person remained conviction-free. That won't happen again if this bill continues. So this is going to provide home detention for funding for home detention, and make no mistake, home detention is hard to come by. We have to get a judge to order it. There are restrictions put upon it. Many people are on 24-hour lockdown, and you'll hear that from the companies. Also, this works, and the work group could start establishing this, towards a unified system of pretrial throughout the state, which we don't have. This brings into line jurisdictions that don't have publicly funded home detention, like Baltimore City and even in Kent County. This also affects disproportionately people of color. So in conclusion, it only makes sense to continue the successes from last year that funded free pretrial home detention fees for poor people. To do otherwise would be to roll back important reforms. Thank you. I can answer any questions if you have them.
Why don't we wait till all the panelists have concluded their testimony, and then our esteemed members, if they have questions, will ask.
I'm very tall. It's very hard to lean over here. My name is Christopher Dews. I'm the Senior Policy Advocate of the Job Opportunities Task Force. Our mission, as always, is to help lower-wage workers advance to higher-wage jobs. And, of course, we're going to be in support of Senate Bill 704 as a means to ensure that lower-income individuals do not find themselves criminalized for their inability to pay for pretrial home detention. As was already mentioned, last year's bill kind of made a miracle play, where now, thanks to the incredible work of the judiciary under Judge Morrissey, there is a program that is basically covering the cost. And just so you can get a little bit of numbers here, since October the 1st, just one company has had over $300,000 paid for by the judiciary for lower income individuals. 400 Baltimoreans per month have taken advantage of that one company's program. And just to be clear, if you did not have this program, individuals will be paying $300 to $500 a month, depending on which jurisdiction they're a part of. This program works. It's very clean. It's very efficient. It's very effective. As Todd has already mentioned, as the Senator has already mentioned as well, we got to keep it in play until we can find another way to handle the cost of indigent persons on pretrial home detention. One last thing I want to highlight that Todd had mentioned was that if you are not found guilty in your trial, you don't get that money back. It's not like bail. It's just lost forever. So this has siphoned out millions and millions of dollars for lower income persons. And so, you know, if we can put this back on the state, and it would be just unbelievably beneficial. And we're not the only ones to think like this. In Baltimore County, if you are not aware, in January 2021, because there was a 30% rise in fees, they decided to move to cover all individuals on pretrial. The last thing I'll say is how the program is working, and it's as simple as this. If you qualify for a public defender, the court pays the bill. If you are using a private attorney, then you submit paperwork, and then the court pays the bill. It is a quick, efficient, easy process. We need to keep it going, and we need the work group to figure out how we're going to have next steps. For those reasons, we urge a favorable report, and thank you for your time. You got it, Sam.
My name is Samantha Blau. I'm the Policy Director at Baltimore Action Legal Team, and we urge a favorable report for this bill. Since 2015, BALT has operated a community bail fund. Since March of 2020, we have operated a home detention fund. Since we started paying for private home detention for residents in Baltimore, we have spent close to $300,000. That is $300,000 of community funds that we have spent in order to cover court-ordered pretrial home detention. Now, I can't tell you how many people in Maryland are put on private home detention, neither can the Department of Legislative Services, nor the judiciary, because the state is not right now counting this. Those people are considered released on recognizance. So this is not something that we're even measuring at the moment. When a judge orders someone to home detention in a jurisdiction that does not have a GPS monitoring system as part of the pretrial services, they're absolving the state of responsibility for that person. The defendant is being moved from state custody to be monitored and imprisoned in their own home at their own expense. The detained person can be restricted from going to work, from earning an income that would allow them to pay their rent and for that home detention. They can wait for over a year in order to attend that court date. You guys need to understand that our funds, BALT's funds, are running down. In the next 2 months, we will need to stop our coverage of private home detention for people who are not considered poor enough by the state to even qualify for this program. If this bill is not passed, we will not be that safety net for people anymore. No one is going to be there to catch the people who will have their poverty compounded by the state's inaction. We urge a favorable report. Thank you.
Good afternoon, everyone. My name is Yolanda Bond-Gregg, and I am currently on pretrial. ASAP Home Monitoring Detention Program. They have been charging me $500 a month while waiting trial, money that I nor do my family have. The court program has been paying the fees for me, and it has been working, and hopefully it will stay in place. I have colleagues that were unable to pay the monthly fees for the home monitoring, and they were rearrested. I have some challenging issues coming up where I'm getting ready to have open heart surgery again. That was one of the conditions of me being released. I had surgery 10 years ago, and now my mechanical and my aortic valve is failing me again, and I have to have surgery. This program has been helping me thus far. Next month, I go back with my cardiologist, and we're going to sit down and we're going to figure out how we're going to go back in, and we're going to do this surgery. If this program is taken away, then I am gonna be completely lost, because there's no way that I would be able to cover any of the fees if I'm trying to recover from open heart surgery. So I just pray that everything stay go. Thank you.
Thank you, Ms. Gregg. Questions of the panelists? Senator West.
Thank you, Madam Chair. The question really, I guess, is more for the sponsor, since we never had a chance to ask questions of her. So you probably ought to go, because that way the camera would be on you.
Senator Hittleman, you could probably answer from where you're sitting if you like.
Can the camera cover both of us? I'm not sure.
It cannot, okay, go up there, Senator Hittleman.
So I think this program is great. I'm 100% in favor of it. But the program was started by the judiciary last year in the middle of the pandemic using federal funds, and they were great to start the program. I think it's inappropriate, and I want to ask you why you think it is appropriate to charge them with the continued operation of the program and the funding of it. I'm looking at their
Right.
opposition, which is really quite forceful.
Right.
Sometimes I disagree with the judiciary's opposition, but in this case, I think it resonates. It says, judiciary is adamantly opposed. Having the judiciary administer this program is inappropriate. It creates a conflict and the appearance of impropriety, especially since there are so few licensed companies. Moreover, the judicial branch of government is not in the business of detention services or the licensure of providers. These are executive branch functions. They always have been and should remain so. All detention facilities and services and any necessary licensure of private home detention providers are currently run by executive department agencies. The judiciary does not have the expertise to administer such licensure or to assess the competence of these providers. So what is your response to that?
So, yes, my response is I said this earlier, and you may have missed it, but I have had conversations with Judge Morrissey about this, and I am well aware of what is in their testimony as well. So I think that it would be entirely appropriate for the committee to look at the bill and contain it to the rest of the federal funds. This process is up and running, and as you heard, efficiently and effectively, and so I think there's a short-term solution here and a longer-term solution here. And I think the short-term solution is these funds have not been exhausted. I don't think we're quite close to exhausting them yet. We would not want the program to sunset, which it will if we do not take action. So I think the short-term solution is contain it to the continued administration, not ask them to go beyond it. And then that is the longer-term solution, hopefully will be arrived at through the work of the work group.
That sounds great. That's not the language of the bill, but
I
it
know.
sounds great.
I know.
Thank you.
Senator Hittleman, and it's been working well under judiciary so far, right?
It has
It's
been.
been very effective and
It has been.
efficient, so I just wondering why they can't continue if it's been working well already.
Well, the bill does say that the funding would have to come out of their budget. And so I understand
So
their
that's is
opposition
that their
to that.
objection?
Yes.
Could it, if it were transferred back to the executive, would they be able to still partake of the American Rescue Funds? Would they still be able to use the federal funds?
If it were, I don't know, the question is who would then administer the program? I mean, all of the pieces are in place right now, and so I would hate for us to change that in the middle of using the ARPA funds.
So you're proposing just continue it as it is?
Until the
and
funding
the work
stream
group makes the
ends.
recommendations?
Correct.
And then we'll go from there?
Right.
Okay.
And as somebody said, I think it was Mr. Oppenheimer said that I think that this has been an issue before this committee for many, many years, the differences among our different jurisdictions with regard to pretrial services. And so some have them, that are pretty robust, and some do not. And so that is going to be something that this work group will have to take a look at. And then in terms of finding the resources to address those jurisdictions. I mean, my own Baltimore County in the face of rising costs of monitoring, decided that this was something that the county had the ability to step up and pay for. And they thought it was a really important thing to do. And so I give great, credit to my county executive for instituting that program. Now, some do not. And so therefore, there is a reliance on private companies to do that monitoring, and here we are.
Okay, thank you.
Okay, thank you.
Any further questions of the panelists or of the sponsor? Okay. Seeing no further questions, can we get the other witnesses up? Thank you, panelists. Yeah, which ones do we call first? Is there an order? Okay. Is this it here? Where is it, Daniel? Oh, is Danielle Winchester here? And Frank Boston, there you are, okay. And Ari Plott?
Yep.
And is there any other panelists?
Marianne Lima.
And Nicole Hanson Mondale?
She's not able to make it, I'm sorry.
Okay. Are there any other panelists? And Nicole Harlock?
Yes.
Oh,
Marianne
yes,
Lima.
there you are, okay.
Oh, no, my name is Marianne Lima.
Okay, yeah,
Oh, okay.
please be seated.
Thank you.
Are there any other witnesses that want to testify on this bill right now in the committee room? Okay, proceed.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chairman, esteemed members of the committee. My name is Ari Plott. I'm from Boston Plott Law, here on behalf of ASAP and Alert in support of Senate Bill 704. We want to thank Senator Hedelman for sponsoring this bill. As mentioned earlier, we are two of the private home detention monitoring companies that will be affected by this bill, but we do support the bill. We are here to serve as a resource to the committee on any substantive or technical questions you may have related to home detention monitoring. We welcome the opportunity to be a partner with the state. However, we continue to provide services, but we still have yet to be paid by the state. We look forward to the work group and the opportunity to work collaboratively with the other stakeholders. And with that, I appreciate your time, and I ask for a favorable report. Thank you.
Hi, my name is Danielle Winchester, and I'm in support of this bill. I'm the Vice President and Program Director at Advantage Sentencing Alternative Programs, also known as ASAP Home Detention. I've been the Program Director for 28 years. During this time, we have monitored tens of thousands of defendants. We are licensed by the Commission on Correctional Standards and Public Safety and are audited to ensure we follow Maryland state law. We have passed every audit and have never had our license suspended. We work very closely with the courts to ensure public safety and that the defendants are doing what is allowed by the court orders. Our program is tailored by each judge's orders. I even have some judges' cell phone numbers to report immediate violations if that's how they want reported. We testify often in hearings and assist with the state's attorney's office and police when a warrant is issued. We work with all counties in the state of Maryland, and the state funding program for indigent defendants is used by all, but not just Baltimore City. When a pretrial client is enrolled in the program, they are qualified by the Commissioner's office as indigent, and their home detention is paid for by this program. The program is not without its difficulties with regarding to getting paid. We feel the judiciary is working tirelessly to ensure invoicing is done properly and required paperwork is received. Although we have not yet been paid, I am assured that this will happen, and it's just a matter of time as opposed to the state not approving people or having the funding. I can assure you that this issue is not compromising the safety of the public. I look forward to being part of the work group and looking to a deep dive into these issues. I'm happy to answer any questions.
Thank you. We'll have questions after all the panelists have completed their testimony. The next witness, please.
Good evening. My name is Marianne Lima. I'm an attorney with the Public Defender's Office in Baltimore City, and my primary focus is on pretrial litigation. So day in and day out, I challenge pretrial detention. So I've seen firsthand what many of my fellow supporters have said about the vital impact that this legislation has on our clientele. Importantly, however, I've also seen how it's assisted with reducing the pretrial population, particularly during an unprecedented global pandemic. We're seeing that it has a clear statewide impact, as noted by Senator Hedelman and my colleague, Mr. Oppenheim. Jurisdictions without pretrial services used to be a default that those judges would keep those incarcerated who could not afford any other options, even though they might be appropriate pretrial release conditions. Incarceration should never be automatic just because there are no alternatives, and this legislation provides a good solution to that. We also have a client who resides right over the state border in Delaware. He was 20 years old, had never been in jail, but pretrial services was refusing to supervise him because technically he was out of state. He is now gratefully at home due to private home detention, awaiting his trial date. But another big change I could speak to, and perhaps benefits actually the judiciary, is actually the reduction in pretrial litigation. Because it's readily available at the bail review, judges can make a determination immediately and not requiring any other motions or hearings and taking up court's precious docket, particularly in light of COVID-19. We also no longer have to seek bail modifications on the basis of clients being unable to continue paying out of pocket for their own freedom, which was all too common prior to this legislation. I actually personally had to file approximately 5 total motions on behalf of one client and argue 3 or 4 hearings before appropriate conditions were set. I believe that for all these reasons, we must continue the legislative trajectory to replace pretrial incarceration as the norm and by providing these alternatives and continuing this effort. Thank you.
Thank you, Ms. Lima. Mr. Boston.
Good afternoon, Madam Chair, members of the committee. I'm Frank Boston III, and I'm here on behalf of ASAP and Alert, the two dominant companies that are in this space and do the actual home monitoring. And we are here in support of the bill, and we want to thank Senator Hedelman for staying on top of this issue and making sure the time is expanded. As my partner, Mr. Plow, said, we're team players. We understand the goals of the legislation, and we're supportive. But this committee and should actually use us as a resource. After all, we live and operate in this space every day. From start to finish, from the contract to the actual person who violates, the ankle bracelet. So, to the extent that you have questions, any one of you, that you need to understand as to how the process works, how the financing works, what the different charges are versus public versus private, please reach out to us. We're here. We can help you because Ms. Winchester and Mr. Slouch, who owns Alert, is here, but didn't get it signed up properly in time. But we are here. They've been doing it for many years. We're here to be your resource. The final thing that I do want to emphasize, and I want to do it in a gentle way, is since October, we have been compliant with the program. We've been doing everything that's been asked of us, but haven't gotten paid 1 cent. And so, just take note of that. I noted the judiciary has been, receptive and understanding, but we've been doing everything. We haven't gotten paid yet. And so we just hope, as we figure this thing out in the work groups, that, we have expenses and costs that need to be accommodated for. Thank you.
Thank you, Mr. Boston. I don't see any other witnesses that have signed up. So are there any questions of panelists from my esteemed colleagues?
Yes,
Seeing none, we have no opposition that have signed up, so that ends the hearing for SB 704, and that ends the hearings for today's committee.
Madam Chair, I think Mako may have signed up. Do you have Nicole Harlock on your?
Yes, we do. Would you like to testify on behalf?
I think she's here if you give her a moment.
Oh, yes, of course. We didn't see her. Please.
She's in support as well.
Okay. Please.
If you called my name, I'm sorry, I couldn't hear you. Thank you, members of the committee. My name is Nicole Harlock. I am the Maryland Association of Counties Fellow for this 2022 session. The bill reaffirms the state's commitment to allowing indigent defendants awaiting trial to maintain some freedom and the prevention of overcrowding and stretching of resources at county correctional facilities. For this reason, MACO supports SB 704 and urges a favorable report. Thank you.
Thank you. Any questions of this witness? I see none. That ends the hearing at SB 704, and that ends our committee work. Colleagues, I've been told by Chairman Smith to take a 15-minute break and come back for a voting session.